All right, I'd like to call the the third and a half meeting of the Courts of Justice meeting to order. The clerk call the roll.
Mr. Chair, you have a quorum.
Great. Thank you, MJ. Okay, ladies and gentlemen, we have a whole bunch of firearm-related bills today, and leading off the docket, I think we have Senator Favola as the first one up on the docket.
Good morning, Mr. Chair and members of the committee. I ask you to draw your attention to Senate Bill 47. What this bill does is it makes a clarification in current law for individuals who are the subject of a protective order, or they have been convicted of an assault and battery of a family or household member. In each situation, they're required to forfeit their firearm for a period of time. They have three options. They can turn their firearm over to a licensed firearms dealer, they can turn their firearm over to law enforcement, or they can transfer their firearm to a transferee or a recipient. My bill addresses the process by which that firearm should be transferred. Under my bill, the transferee would have to complete a court form and turn it over to the court. So the offender or the subject of the protective order has to ensure that the court has a form that indicates who the recipient of the firearm would be, name, address, etc., and the recipient of the firearm gets a copy of that form. The recipient, of course, has to be eligible to have a firearm based on background checks, but we do add the age of 21. The only other thing my bill does is it clarifies that a search warrant could be issued if there was some reason to believe that this law was not followed. That's not new law. A search warrant could be issued anyways. We were asked to by advocates and others to just clarify it in this bill. We believe this bill is very necessary. Again, it doesn't change who can possess a firearm. It only ensures that our current law is followed. And we put that protection in by having the court receive a copy of a form stating who the recipient of or who the transferee is. We have learned from groups that serve survivors of domestic violence, groups that really provide guidance and counseling to survivors of domestic violence, that they believe the person who they're trying to seek protection from, and the law has provided them with some protection, that person is not actually transferring the firearm, and the firearm is still in the hands of an abuser. So we believe this is the right thing to do, and I just want to remind the committee that an individual who is in a household where there is an abuser has 5 to 7 times more likely to die if there's a firearm present. So I will conclude my testimony. I believe there are some folks who may want to speak to this bill. Thank you.
Hey, Senator, just so I'm clear, I think we passed a bill that was similar to this, 9-6 last year, and the only thing different is that you added the notification of search warrant this year. Is that right?
That's correct. Well, and there's one other thing. Last year, we didn't have the form that had to be filed with the court.
Okay.
So there are 2 items that were different.
Great. Thank you. MJ, can you set the timer at 5 and 5, and all those in favor? And do we have any online?
If you're online and wish to speak electronically, please raise your hand now.
Okay, all those in favor, can they come up to the podium?
Mr. Chairman, members of the committee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We represent Virginia's 70-plus sexual and domestic violence agencies statewide, and as Senator Favola mentioned, domestic violence advocates and our practitioners are very much in support of this. This is just a clarification of the law. It aligns protocol across protective orders, across substantial risk orders, and for misdemeanor DV convictions. We were just out in the field training law enforcement and judges down in Southwest Virginia, Pulaski, last week, and sent this bill to them, and they very much said, yes, please, this is incredibly needed. So this is going to be very, very helpful in terms of ensuring robust implementation of the law, and it's something that survivors are also asking for. Thank you.
Thanks. Anybody else? Everybody needs to come up to the podium so we can move it along.
Yes, sir. Good morning. My name is Lori Haas. Mr. Chairman, members of the committee, we definitely support this bill. Compliance with the law and enforcing the law is something that's necessary in the Commonwealth of Virginia to protect victims of domestic violence. This just ensures, again, compliance with the law. If a person has been deemed prohibited from purchasing, possessing, or owning transporting firearms, we need to ensure the courts and law enforcement that they have clear guidance on how to make certain that enforcement applies. We support the bill. Thank you.
Good morning, Liddy Ballard from Brady. We strongly support this bill as a way to support victims of domestic violence, and we urge the committee to report this bill. Thank you.
Good morning, Taye Mallory with Virginia NAACP, and we support the bill.
Okay, is there anybody online? Nope. Okay. Can we reset the timer? Is there anybody opposed to the bill? Make sure you come up to the podium and get in line. Mr. Van Cleve, welcome to the committee for the first time this year.
If you're online and you wish to speak against this bill, please raise your hand electronically.
Thank you, Mr. Chair. Yes, we oppose the bill. For example, there are cases where, say a husband had a protective order that didn't deal with the wife outside the house. This would take away, if he had a firearm in the home, a shared firearm, this would take the firearm away from the wife. Currently, a felon can be married to somebody that's not a felon, and the person that's not a felon has to keep the gun locked away from the felon, but they can have the guns in the same house as long as they're complying with the law. Thank you.
Good morning, Chairman, members of the committee. My name is Taylor McKee. I'm with the National Rifle Association. The NRA generally believes that a felony ought to be the only penalty that deprives somebody of their civil rights, specifically the Second Amendment. Thank you, Chair.
Is there anybody online? Okay. Senator Favola, sounds like you have a cold committee today. Not a lot of questions. You have the final word.
Well, I just want to remind the committee that we have always focused on enforcing the laws that we pass. That has been a priority of the Senate, and this is just a tool to enforce our current law. I would really ask that you support this bill.
Okay. Is there any further discussion? Is there a motion?
Mr. Chairman.
Okay, Senator McDougal.
Motion. Maybe this is a question for Mr. Benjamin. On line 40, it says reason to believe. I think historically for a search warrant, you need probable cause. Is that similar language to what we've used in other things?
Don't know that I don't know if we've used similar language, but it would not alter the requirement of probable cause for the issuance of a search warrant.
Mr. Chairman.
Senator McDougal.
Why not? Because it says protected order an officer may obtain if they have reason to believe. If you want to mean probable cause, why wouldn't you say probable cause?
The reason is because this provision does not authorize the issuance of a search warrant. It's just a notification provision.
Mr. Chairman, when that question came up with our work group, we were told that the same process for seeking a search warrant would still be in play.
I mean, Senator, the way I read it, it's just a notice to the person on the form. It doesn't change the substantive law, but
Mr. Chairman, I just saw it as using more easily understood language to a layperson than the probable cause recitation.
Mr. Chairman.
Yes, Senator McDougall.
Different question.
Okay.
So if my understanding of the current law is that someone under the age of 21 can legally possess a shotgun, is that accurate?
I think that is true.
Mr. Chairman.
Senator McDougall.
So this would say that you could not transfer a shotgun to a 20-year-old.
That's correct. It does.
Thank you, Mr. Chairman.
Okay, any other questions? Okay, it's been moved and seconded that we report the bill, and does this need to go to finance? Does not.
No.
So this goes to the dance floor. Okay, clerk will open the roll.
Ayes 9, no 6.
Okay, the bill reports 9-6.
Thank you, Mr. Chairman.
That's your only one, right?
Good day.
Yeah. Okay, next I have up Senator McGuire, who I don't see unless he's behind the podium. Oh, there he is. Okay, Senator McGuire, you've got, I think, 82 concealed weapons permit, right?
Good morning. Thank you, Mr. Chairman, members of the committee. Today, before you, I'm going to present Senate Bill 82, a concealed carry bill. We want to change the terminology from concealed handgun permit to concealed weapon permit. I present to you, this introduces changing a concealed handgun permit to be stated as a concealed weapon permit. This will allow Virginia residents who currently possess a concealed handgun permit prior to July 1st, 2024, and also those who apply for a new concealed permit from being reprimanded of illegal carrying of some allowed weapons other than handguns. Exceptions to said weapons are stated in the bill on pages 2 and 3, lines 119 to 135. A person carrying a concealed weapon with an obtained concealed weapon permit can carry in any place, area where carrying concealed handgun with an obtained concealed handgun permit is legally allowed. Our residents have a constitutional right to basic liberties and individual protection as long as it is not endangering to others uninvolved. To bear arms means to protect oneself as is necessary to the security of a free state as outlined in the U.S. Constitution. The U.S. Supreme Court's decision in 2008 of District of Columbia versus Heller further constitutionalized the right of self-defense and described self-defense as natural inherent right. And I'll repeat, this bill basically changes concealed handgun permit to a concealed weapon permit. This change gives permit holders more options for self-defense by allowing the carry of less lethal weapons. And Florida and some other states have concealed weapon permits. Virginia had a concealed weapon permit until 1995 when they changed it to concealed handgun permit.
Senator, thank you for the presentation. Here's some questions I had. So I was in Japan last winter. My son and I went to the Ninja Weapons Museum. And we threw some throwing stars, and I was horrible at it. They all hit the floor, and I can understand like demonstrating competence of something like throwing stars or those kinds of things. But I was also in Honduras a few years ago, and one of my drivers, I asked him why everybody had a machete, and he said, su machete es su pasaporte, which means your machete is your passport in Honduras.
Mm-hmm.
How do you,
I've been there
how
many
would you,
times.
Yeah, so how would you demonstrate competence with like a machete or like one of these other weapons you got on the list, like a, I don't know, like a blackjack or a ballistic knife or nunchucks?
Right. Well, I guess it would be the same thing as mace and things like that. I mean, those are simple weapons to use to defend yourself.
Okay. Are there any other questions on the committee for Senator McGuire? No other questions. Senator, do you have anybody who wants to testify in favor? Okay, why don't we set the timer at 5 and 5?
Thank you.
If there is anyone online that would like to speak to this bill, please raise your hand.
Mr. Chair, Philip Van Cleve, VCDL. Yeah, we support the bill. I mean, having options for a permit holder to have less lethal options is I think, a good idea rather than having only one option, which we currently have. Thank you.
Good evening, Chairman. Taylor McKee with the National Rifle Association, and we support the bill.
Expanding your mission.
Patricia Webb, Virginia Citizens Defense League. I support this bill. We allow people to carry guns. There is no permit required to open carry a gun, just to conceal it. There's no reason why we should not also afford that same opportunity for other weapons that are less lethal, may be more convenient. Thank you.
Great. Anybody else in favor? Anybody online? Okay, let's reset the timer. Anybody opposed to the bill? Come on up to the podium.
If anyone online would like to speak against this bill, please raise your hand.
Mr. Chairman, members of the committee, Andrew Goddard, Virginia Centre for Public Safety. I noticed that people are using the term less lethal. They're not using the term non-lethal. I think that I listened to a presentation recently on the proliferation of gang members in Virginia, and I believe that taking this law and making it more expansive would take another tool away from our police to deal with that gang problem. Thank you.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. I just want to note that in my years, many years in this building, or not this building, this one, then that one, now back to this one, law enforcement has never been supportive of this. They've always been speak to the narrowness of a concealed handgun permit. It allows a person to conceal a handgun and no other weapons. We oppose the bill.
Talia Mallory again with the Virginia NAACP, and we oppose the bill.
Sorry, is there anybody online, by the way, opposed? No? Okay. Yes, Senator McGuire, final word.
I just say thank you guys for considering. You know, it's our God-given right to protect ourselves, our family, and our children, and we need to do everything we can to make sure we're not helpless victims. Thank you.
Okay.
The report.
It's been okay with substitute motion. Okay, it's been moved and seconded. The bill be PBI'd. Any further discussion? Clerk will open the roll.
Ayes 9, no 6.
Great. Thank you, Senator. Is that your
Thank
only
you.
one? Guess so. Senator's third event. Let's see. You've got. Do you just have one?
Yes, sir. Mr. Chairman, good morning.
Right. I'm going to repeal some red flag orders, right?
Yeah, I was a little surprised to be on the gun docket this morning. I've got a Fourth Amendment bill in front of the committee this morning. Senate Bill 639. It's just a repeal bill. I'm a personal injury trial lawyer, small country lawyer. I was going through the code to kind of refamiliarize myself with some of the criminal procedures. Was looking at 19.2 title of the code, which is criminal procedure, and saw a couple of statutes in there, Mr. Chairman, and I'd ask you to look at it from the context of a Fourth Amendment illegal seizure. You know, we've got, from what I remember from criminal procedure in law school, we've got basically three law enforcement interactions. You've got a consensual interaction, you've got a Terry stop, and then you've got an actual seizure where your Fourth Amendment rights kick in. And in this particular statute, 19.2, 152.13, in Section C, it says that upon service of the emergency substantial risk order, and so this is law enforcement now, an armed sheriff's deputy or police officer going to an individual's home and serving them with this risk order, they're also saying that they have the opportunity to voluntarily relinquish any firearm in the person's possession. But, you know, this is clearly not a consensual encounter. the individual doesn't have the right to leave or to refuse service. It's not a Terry stop. It's on somebody's front porch at their front door in the curtilage of their home. And so unless there is another category I'm unfamiliar with, it's got to be an actual seizure, a Fourth Amendment seizure. And along the lines of what the Virginia Supreme Court says about these three different law enforcement interactions, it does say there's no litmus test for determining whether an encounter is consensual or constitutes an illegal seizure. However, if a reasonable person would not feel free to decline an officer's requests or would not feel free to leave, the encounter is not consensual and constitutes an illegal seizure under the Fourth Amendment. And along those lines, the same Virginia Supreme Court case, Harris versus Commonwealth, listed some non-exclusive factors relevant to the totality of the circumstances for assessing whether a seizure is illegal or not. And among those factors are the threatening presence of a number of police officers. That's not necessarily applicable here if you just have one police officer serving the order. The display of weapons by officers, you could have that in a situation like this. Physical contact between an officer and a citizen, not necessarily the case here. An officer's language or tone of voice compelling compliance, not necessarily the case here. But what the Virginia Supreme Court does say takes it from that reasonable person standard into an illegal seizure is, quote, the retention of documents by an officer. And so when that order gets served, the individual's got to sign that they received it. Documents go back to the officer. The officer retains those documents, but also the weapons. The police officer says you can voluntarily relinquish any firearms you have, and the officer takes those firearms into custody. And that's along the lines of the retention of something by an officer from this interaction, making it a seizure. And then the last factor is whether a citizen was told that he or she was free to leave. And again, when a officer is directed by the court to serve this order on a citizen, there's no right to not accept service. And so for all those reasons, this takes it into the category of it's not a consensual stop, it's not a Terry stop, it's got to be a seizure. There's no Miranda rights given. There's no right to counsel afforded to the individual. No right to confront one's accusers. And so, simply put, it's an illegal seizure. And then one of the things that the statute requires is that the clerk transmit the information about the individual subject to the order to the Virginia Criminal Information Network database. And the statute also requires that a registry be kept of all the people who are subject to these orders. And to the credit of Fairfax County, while the statewide registry is not made public or available to average everyday citizens that I'm aware of, at least, the Fairfax registry is online, and you can go look at it. It's on their website. But what I would bring to the committee's attention, and which I think is especially relevant here, is that Fairfax County, according to the county demographics, is, as of April 2020, 9.4% of the population in Fairfax County is African American. On Fairfax County's own website, with the race and ethnicity demographics of who have been subject to these emergency protective orders, 30% of these orders have been issued against black and African American citizens in Fairfax County. So it's about 10% of the population of Fairfax is black. 30% of the emergency risk protective orders issued in Fairfax have been against black African American citizens in Fairfax. And so it tripled the rate of the African American population in Fairfax County, which is higher than the rate of blacks, African Americans incarcerated in Virginia. It's about 20% of the population in Virginia is African American. About 45% of the population in jails is African American. About 55% in prisons is African American. So it's
Senator Sturman. I think there's a question up here for you,
Yes, sir.
Senator Deeds.
And I hate to interrupt the legal analysis, and I appreciate your thoughtfulness, but I'm looking at the record, and in 2019 you voted for legislation to enact the red flag law. What's happened since 2019 to today, in 5 years, to make you want to repeal it? I mean, of course, it wasn't enacted in 2019.
That's right.
We had to wait for a year.
Yeah.
But you voted for it in 2019. Now you want to take it off the books. How come?
Yeah, so the 2019 bill was a George Barker bill.
Right.
I've not gone back and done a line-by-line comparison of the two, the George Barker bill that he brought several years in a row versus the one that was ultimately passed. My recollection is that there are substantial due process and timing differences. But I would also say we've now had a couple of years to see this in effect in Virginia. We've also had the intervening Bruin decision. And so I'm approaching this, I understand the makeup of the committee. There are Second Amendment problems, obviously, with this from my perspective. From a Bruin perspective, there's no historical analogs. But given the makeup of this committee, and we've got new lawyers on here and folks with prosecutorial backgrounds and criminal defense attorney backgrounds, I think it's important to take a very close look at this from a Fourth Amendment perspective. And the other thing that I would bring to the committee's attention, we had Senator Salim's first bill up on the floor last week about changing the misdemeanor penalty from 365 days to 364 days because of its potential impact on deportations. And what I would bring to the committee's attention is that this emergency risk protective order has the exact same problems. It triggers the federal deportation statute, 8 U.S.C. 1227. And I would argue it's even more egregious because there are non-citizen legal immigrants who can own and possess firearms while they're living in this country. But getting hit with an emergency risk protective order automatically triggers this deportation statute. So you could have somebody who's been here for 30 years on a green card, doesn't speak the language or have any family back in the country that they came from, and by getting hit with one of these orders has a real potential, just like with the misdemeanor statute that this body passed and that was passed on the Senate floor.
Mr. Chair,
Senator
do
Deeds.
you have examples of that very situation happening since the emergency risk order has been the law of Virginia?
I don't, but I think it's important for this committee, just like with the misdemeanor change statute, for the potential as we have larger and larger legal immigrant populations in Virginia. And what I would argue what makes this even more egregious is the fact that no crime has been charged and no one has been convicted of a crime, and yet they would still be subject to deportation.
Hey, Senator, so I helped Senator Barker rewrite his law in 2020 so that it had actual, a lot more due process protections than his original law in 2019 did. And I would just note that the way we rewrote it, I think you actually have more due process protections over the government taking away your gun temporarily than you do being kicked out of your house for a domestic violence protective order. But I would, I pulled the data because I have a bill up here later in the docket. There's been 1,115 red flag orders issued since the law went into effect through, I think, July the 11th. Don't you think if there was a constitutional problem with the bill that one of the 1,115 lawyers that represented somebody on this case would have argued that and the court would have found it by now?
They don't have a right to counsel, Mr. Chairman, and so some of them may, but the way that this statute is written, they are not afforded any of the constitutional rights that a criminal defendant would have when they are hauled before a court and arraigned. And I think that's the very problem. Not to mention the fact that you have a law enforcement officer who is armed going to someone's front door of their home and saying, please turn over the firearm that you have. Again, you're getting into self-incrimination problems potentially there as well. So, I understand that the intent from many for legislation like this is often well-intentioned, but that doesn't absolve us of our duty to look at this from all constitutional
Hey,
perspectives.
Senator, looks like Senator Perry has a question.
Senator Sturdivant, I have a couple of questions about this. My first question is, you're talking about Miranda and the rights of the person who has to turn over the firearm. Substantial risk orders are civil protective orders, right? And Miranda is a specific decision that attaches to criminal cases. Is that right?
And the point I'm making here is that it becomes an illegal seizure, thereby requiring Miranda when you have the police officer serving the order, directing them that you were potentially...
I don't think that Miranda applies to whether or not something's a legal seizure. I think the law Miranda applies to whether
Senator
someone...
Perry, just remember you got to go through the chair.
Mr. Chairman.
Senator Perry.
Whether someone's in custody and being interrogated, that's when Miranda starts to attach, and that wouldn't be applicable in the service of a civil order, would it?
Well, Mr. Chairman, just because we identify it as a civil order doesn't make it a civil order. It's in the criminal procedure title of the Virginia Code. It is only issued after there is a probable cause finding of some enumerated actions by the individual. And so it is the totality of the circumstances when taken together that I think indicate pretty clearly that this is not just a civil order.
Mr. Chairman.
Senator Perry.
And Senator Sturdivant, as a prosecutor, I know you referenced that earlier. I actually was one of the people I was the person actually for Loudoun County who handled substantial risk orders for the county. Actually, the one and only for after this law got passed until I left the Commonwealth Attorney's office. And certainly, I can tell you that every case that I handled. Those individuals were represented by counsel, and you would agree with me that you can have representation and that rights are afforded and that the burden is on the Commonwealth to prove not only at the initial hearing, which is a subsequent very short turnaround from when the firearms are taken, but thereafter multiple hearings to ensure that those firearms still meet the standard of that person being a danger to themselves or others if they continue to possess them. So counsel can attach and can be present to pursue the things that you're speaking about. Isn't that right?
If they have the means to pay for it themselves, and I think that's the distinction here. If they were charged with the crime and brought before the court and couldn't afford it, they would be provided with counsel, which is not afforded here. And I think, again, it can't be a civil order just because we say it is if it's the attorney for the Commonwealth who is the one who is pursuing the issuance.
And Mr. Chairman,
Senator Perry, then we'll go to Senator Stewart.
Mr. Chairman, Senator Sturdivant, there is no other example in the law where the right to court-appointed counsel applies to civil cases. Isn't that right?
Except termination of parental rights.
Termination of parental rights.
Yeah, and the point I'm attempting to make, Mr. Chairman, Senator Perry, is that we've gone beyond this being simply a civil order, a civil procedure. We can't put in the code that waterboarding is not torture and assume that that's what carries the day.
Mr. Chairman, if I can, one more time before I turn it over to, or you turn it over to Senator Stewart. Senator Sturdivant, you talked about the case of Bruin before the United States Supreme Court. The United States Supreme Court decided recently, and you referenced it in relationship to this law. But I think one thing that is interesting about Bruin is Bruin talks about and is really rooted in the fact of what has historically been the case, right? How have we historically regulated firearms in this country? And in fact, it goes all the way back to British common law, the idea that we don't believe and have historically not believed that folks who are suffering from mental illness, or I think they used to refer to it more as mental infirmity, should have and possess firearms. So I think it's fair to say that even under Bruin, these types of laws would be upheld under that standard.
Mr. Chairman, there's room for debate there. I respectfully disagree, but that's why I wanted to bring this to the committee's attention from a different perspective that perhaps can have some bipartisan agreement on.
Senator Stewart.
Thank you, Mr. Chairman. Interesting discussion regarding the civil versus the criminal aspect of this and the Miranda, but one thing we should all remember, they are coming in to someone's home to make a seizure. And yes, that is under civil order, as Senator Perry's pointed out. But frequently, the officers will see things in plain view or things that will lead them to make an arrest, which implicates Miranda. And we're all very familiar with this. And that is the part that disturbs me about this bill the most. And we debated this on the floor for a very, very long period of time. And there are those in here that would say you're affording someone due process by giving them a hearing after the seizure's been made, but that's not what due process is. And I want to compliment Senator Sturdivant. He's a personal injury lawyer. I don't hold that against him. But after he did a little bit of research...
Or your chairman, by the way.
After he did a little bit of research into the Fourth Amendment and illegal searches and seizures and all the things that come with that, he now understands the true application of due process. And we should be affording these individuals due process before the seizure is made. And I just hope that those of you all who were here and voted on this bill originally will have that same epiphany and understand that we should be giving these individuals due process before that seizure is made. It's easy enough to do. You go in on the same civil order as we've discussed before, and you bring them in for a hearing before you take things that belong to them.
Okay, thank you. Any other questions for Senator Sturdivant before we take testimony? You'll get to talk at the end too. So
Pardon me?
you'll get to speak at the end too. I'm not sure if you're done your presentation, but okay. Why don't we set 5 and 5? Is there anybody in support of the bill?
If anyone online would like to speak in favor of this bill, please raise your hand.
Chair Philip Van Cleve, VCDL. Yeah, I can't, I think he's covered everything. We strongly support the bill. Thank you.
Thanks.
Mr. Chairman, Taylor McKee from the National Rifle Association. We support this bill. We have the same constitutional concerns that the patron did as well, primarily the due process concerns, thinking only disqualifying convictions and proper mental health adjudications should be sufficient enough to deprive somebody. Thank you, sir.
Good morning, Mr. Chairman. Patricia Webb, Virginia Citizens Defense League. I would like to point out to the members of the committee that the New York Supreme Court struck down the New York red flag law recently because there were no medical professionals involved in the decision whether to issue the red flag order or not. Virginia's law is substantially similar to that. We have no medical professionals required in the evaluation of the decision to issue the red flag order. It goes through the court system and the police. In addition, there's no help for the person that is supposedly in crisis or a danger to themselves or others. You leave them alone and unsupervised with no psychiatric help, no follow-up, no supervision. So in essence, what you've got is the thought police deciding somebody may do something bad, so we're going to do something about it beforehand, and that's just Orwellian and wrong. And I urge you to support this bill. Thank you.
Mr. Chair, there was no one online to speak for this bill.
Sorry. Can we reset the timer? Okay, all those opposed, come up to the podium and check if we have anybody online.
Mr. Chairman. Andrew Goddard, Virginia Center for Public Safety. We strongly oppose this bill. The severe risk protection order is a great tool for public safety. And to address the idea that was brought up about a racial disparity, perhaps one race is using the order more than another. Maybe they're availing themselves of the protections provided by this order at a rate that is different to others. That could explain. It's not being applied necessarily directly in an attempt to pick out one race. And one thing I have to say finally is I can't imagine that all the red states that have put this order in effect didn't think of this ingenious argument.
Hi, my name is Gretchen Garber. I'm a volunteer with Moms Demand Action, and we strongly oppose this bill. This bill does have a wonderful due process. I am also a licensed clinical social worker, and I work in mental health hospitals, and having to call family members and tell them that they have to be the ones responsible for removing weapons from their loved ones discharging from the hospital has been extremely difficult. This is a great preventative measure to help those family members, save those lives of those family members that have that firearm, both suicide and homicide. As a mental health provider, as well as a volunteer, we strongly oppose this bill. Thank you.
Good morning. Liddy Ballard from Brady. Any attempt to weaken or repeal this law will put Virginians' lives at risk, and Brady strongly opposes this bill. Thank you.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. We oppose the bill. We know that this law is working throughout the Commonwealth. It has been used hundreds and hundreds of times across the Commonwealth. The information that's available on the Fairfax dashboard and from Virginia State Police is de-identified. It does not identify any person by their name or location or address or any of those items. It does identify age, race, and gender. Number two, these laws can be used in a variety of situations. Let's be clear that while we typically think of persons in a mental health crisis that this is going to help, there are situations where there are threats. I know of a law enforcement officer in Southwest Virginia. They were working with a gentleman. He threatened his ex-girlfriend. He was abusing alcohol. He threatened the ex-girlfriend. He says, "I'm going to get a gun and kill her." Law enforcement officers were able to intervene in that situation, and based on that threat and based on other evidence brought to the courts, there is a judicial process before the search warrant is issued. They were able to intervene and disarm this gentleman, and perhaps that woman is alive because of this law. We know that circumstances exist where persons are in crisis for a whole host of reasons other than a diagnosable mental illness. Clearly, they've been used in situations where there's a diagnosed mental illness, but there is a variety of reasons why we might want to use and intervene in a crisis. We also know that there is a great deal of due process in this law and in this bill. It's been vetted in courts across the country numerous times. It's the law in over 21 states currently in the United States. It's about saving lives. It's about saving lives. I oppose the bill.
Talia Mallory with the Virginia NAACP, and we strongly oppose the bill. Allow me to also say personally, as someone who has experienced homicide and suicide in her family, I just strongly oppose this bill. Thank you.
Thank you. I think we have two people online. Could we have 55 seconds for those people online?
Aaron Giffords, you may unmute and speak.
Good morning, Mr. Chair. My name is Erin Erb. I'm a state policy attorney at Giffords, and I was an assistant Commonwealth attorney in Virginia for 8 years. I just want to clarify the Fourth Amendment issues here. A temporary detention to serve someone a protective order does not take away their ability to voluntarily consent to turn over a firearm. That there's a distinction between that temporary detention and the seizure of the firearm. It's similar to a traffic stop where someone is pulled over and is asked if the police could search their car. They are free to say no. And so those two things are separate here. I just wanted to clarify that.
Okay, 3 seconds for whoever's left.
Virginia Ravniak, you may unmute and speak.
Well, quickly to say that I oppose this bill.
Okay, and Ms. Ravniak, our policy says if you're going to testify remotely, you have to turn your camera on and identify yourself. Okay. And for everybody else online, please take note of that. We have a policy this year with regard to remote testimony. Okay, that takes it for the opponents. Senator Sturman, you have the last word, unless there's more questions.
Thank you, Mr. Chairman. Thank you for the questions of the committee. Again, I would just say you look at the use of this in Fairfax, more than 1 million people there, and it's at higher rates than traffic stops, higher rates than incarceration, and there's no crime charged or conviction here. And then in line with the misdemeanor bill related to deportations that was passed off the Senate floor last week, this has the very same implications. Thank you.
Mr. Chairman.
Senator Peake.
And I don't know if it's the patron, it might be the chairman. I believe you referenced that there are 1,115 instances of the red flag law being used. Does anybody know how, in those cases, how many times the guns were taken? Do you know?
Ms. Senator Peake, what I can tell you is, the only thing I can tell you about what the data the state police gave me is that 704 were emergency red flag orders and 411 turned into final orders. And that's the only data they gave me. I didn't ask for data beyond that. Okay, any other questions? Is there a motion? And by the way, we heard this bill last year. I think it was PBI 10.5, I think.
Substitute motion.
It was PBI 10.5 last year. Senator Chase's bill. Yeah.
It's a different bill. Very different bill.
Don't we get one? Make it a little closer so we can debate. I think we should push it to the floor so we can have a long debate.
All right. Is there a motion here? Okay, substitute motion?
PBI.
Okay, it's been a substitute motion, PBI the bill. Any other debate? Clerk will open the roll.
Mine's not working.
Okay, we strike the roll and start over again.
Senator Stewart.
There we go.
Ayes 9, no 6.
The bill PBI 9-6. I think that's your only bill, right? Pardon me? It's your only bill today, right? Yep, okay. Okay, Senator Williams Graves, Senate Bill 522. Demonstrated competence with a firearm.
Good morning, Mr. Chair and members of the committee. I bring before you Senate Bill 522 to require a gun safety course. This bill is to require proof of a gun safety course being taken within the last 5 years to purchase a gun. The course qualifications are consistent with the concealed carry approved courses. The intention of the bill is to simply ensure that people know how to handle a weapon, a deadly weapon, safely. We require drivers to have training to drive a vehicle, which if that vehicle is improperly used can be a deadly weapon. And we also, and voting is also a right, as gun ownership is a right, yet we do put restrictions on voting. So I would ask that the committee pass the bill.
Okay, any questions for Senator Williams Graves? Very efficient presentation. Nope. Okay, Senator Williams Graves, you got anybody to testify in support of your bill?
I do believe we have testimony and support.
Okay, we set a 5 and 5, please.
If anyone online would like to speak in favor of this bill, please raise your hand.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support rigorous training for people who are taking firearms into the public space. If they were keeping them in their homes, then it's in their own head. But since they're carrying them out in public, the public needs to be safe. Thank you.
Good morning, Mr. Chair. Liddy Ballard from Brady. It is common sense to ensure that those wielding deadly weapons have completed training that makes them and those around them safer, and we strongly support this bill. Thank you.
I'm Tanya Mallory with the Virginia NAACP, and for reasons stated, we support the bill.
Good morning, Mr. Chair. My name is Melissa Flynn. I'm a volunteer with Moms Demand Action, and we strongly support this bill.
Good morning, Mr. Chair, members of the committee. My name is Lori Haas, and we support the bill. I just would like to make note that law enforcement officers across the Commonwealth are required to undergo hundreds of hours and continue their training to be allowed to carry firearms in public. This makes a lot of sense. Thank you.
Is there anybody online?
Mr. Chair, there is one person online that would like to speak.
Okay, please turn on your camera, identify yourself. And 3.5 minutes left.
My name is Virginia Rosnack. I'm a member of the Charlottesville Coalition for Gun Violence Prevention and also the Charlottesville Center for Peace and Justice. You have a chance here to save lives and make things safer in the Commonwealth, and I heartily support this bill. Thank you.
Okay, that's it. Okay, MJ, please reset the timer. Okay, all those opposed to the bill.
If there's anyone online that would like to speak in opposition to this bill, please raise your hand.
Mr. Chairman, could I ask the patron a question?
Senator Stewart.
Senator, I'm sorry. Could I ask you a quick question?
Sure.
Do you have statistics, and maybe he was talking in my ear and I couldn't hear. Perhaps you cited them. Do you have statistics that we have a great deal of accidents with firearms as a result of incompetence of use?
I do not have statistics to support that question. However, we do see oftentimes on a daily or weekly basis where we have had accidental shootings with guns. And it's not just about accidental shootings, it's simply a matter of public safety. If you're going to carry a weapon, if you're going to handle a weapon, you should know how to use it. I, who have never handled a weapon, could go into any gun store, buy it, get it all boxed up, cute and everything, and then walk out of it and shoot myself or shoot someone else trying to load it. So I just think it's a matter of public safety and common sense.
But we don't have statistics, sorry. I just wanted to make sure about that. I'm trying to find the actual statistics where we have a lot of accidents. We don't have that.
I do not have statistics to answer your question.
Thank you.
You're
Mr.
welcome.
And if I may ask the patron a question to follow up on what Senator Stewart has been talking about. Mr. Chair, I'd ask the senator, when we look at the language here of this bill, it says, if I'm going to purchase a firearm, the seller has to have received from me, the prospective purchaser, proof that such prospective purchase has demonstrated competence. What would that be?
Through taking a gun safety course?
Mr. Chair.
Senator Stanley.
Senator, I respectfully would disagree because it says, or completed a firearms safety or training course as specified in subsection S within the past 5 years. So this is an either or proposition, not an and. So I would then ask, if I'm a gun seller and someone wants to buy a firearm from me, what proof, is it subjective, the proof that I deem that the prospective purchaser has demonstrated competence with a firearm? What's the standard?
The standard is taking a gun safety course. If the person has taken a gun safety course within the last 5 years, that is proof of competence. If the person may be law enforcement or they use a gun in their day-to-day work, that would be proof. But for the average citizen, the proof would be having taken a gun safety course within the last 5 years.
Mr. Chairman.
Senator Stanley.
But you understand your bill doesn't say that you just got to take a gun safety course and provide the certificate to the seller of the firearm. You're saying, this bill says, prove competence with a firearm or take the
the gun safety course. You understand that, right? As
I
part of your bill?
I do understand what you're saying. And again, taking the gun safety course is proof of competence.
And Mr. Chairman, final question. And even though your bill says differently, that is your only test for competence in your mind or your intent of this piece of offered legislation?
My intent for this piece of legislation is that folks have to take a competency course, a gun safety course, in order to be deemed competent to carry a weapon.
Senator Stanley, you done? Senator Stewart, I think, has a question. Although I had a question to follow up on Senator Stanley, unless you're on the same subject. Senator Stewart.
Well, in the general area, yeah.
Okay, go ahead. Senator Stewart.
Or you can go. It doesn't matter. Senator, so I'm trying to go back 30-some years ago when I was in law school and thinking about constitutional law. And when you're trying to restrict a constitutional right, and maybe staff, I see Mr. Benjamin is gone, but I'm curious about your thoughts on this. Anytime you're trying to restrict a constitutional right, there must be a compelling state interest. Is that correct?
Are you asking me?
Well, it may not be fair to ask you, but you may know the answer.
I'm not an attorney.
Okay, all right. So I'll ask whomever can answer that.
There are several levels of scrutiny, and I think the answer is that it depends upon the right that is being that's in question.
In order to, sorry, Mr. Chairman, in order to limit the Second Amendment of the Constitution, which we're all familiar with, wouldn't the state have to show a compelling state interest to do that, such as this bill, for example?
Mr. Chairman, Senator Stewart, as I understand the current state of Second Amendment law, the ends-mean analysis, the strict scrutiny, the compelling state interest test, has been abandoned. And instead, the question concerning any infringement upon the right to bear arms depends upon whether the court can find that there is a historical tradition of that sort of restriction.
Thank you, Mr. Chairman.
I had a question for
Mr. Chair. Can I finish?
Sure. Oh, yeah. No, if you're done.
So if we're analyzing it under that standard, are we aware that there was any historical tradition that you must take a safety course in order to bear arms?
Mr. Chairman, Senator Stewart, that is precisely the question that would be asked to test the constitutionality of any infringement on the right to bear arms.
And I'm asking you, are you aware of any historic tradition?
Well, I'm old, but I wasn't, Mr. Chairman, alive during colonial times. Nor am I aware from my study of history of any requirement at the time.
I think he answered the question finally. You are not aware of any historic tradition to require a safety course or competency test to bear arms.
Mr. Chairman, Senator Stewart, that's correct, but I am not one with historical expertise.
And so, Mr. Chairman, and so based upon that, do you believe that this could have the probability of being found unconstitutional?
Mr. Chairman, Senator Stewart, I was with you until you used the word probability. There is no doubt that any restriction on the right to bear arms will be challenged in an appropriate case. The answer is not clear. The jurisprudence concerning the Second Amendment is quickly evolving. It would have been at an earlier time I could have predicted. That's what lawyers do based upon precedent, what the answer would be. At this point, I can't make that prediction. Nobody can. But certainly it would be challenged.
Thank you.
Hey, so I had a question for either Ms. May or Mr. Benjamin on this same line. So I'm looking at the bill the way it's drafted. And I guess the bill says that you have to present some evidence that the person has demonstrated competence. That's the sort of general concept up top and like lines 112 to 114 or whatever. You have to provide proof that you've demonstrated competence. Then you go down to S, which is lines 288 and 89, All that is a non-exclusive list of ways you can presumptively prove competence, but it's not exclusive because it uses the word includes. Is that right?
That's correct, Mr. Chairman.
Okay, so just so I'm clear, like, let's say in theory I'm at Clark Brothers, I'm trying to buy a gun. In theory, the way this is worded, because it's not an exclusive list, and I don't think it requires a class. It just seems to require proof that you've demonstrated competence. Oh, wait. Right? You've demonstrated competence or completed a firearms safety or training course. It has or. So in theory, I could go out back on the range with the owner or somebody, demonstrate competence with a gun, show them I know how to handle it, load it, whatever. If the person selling the gun thinks that me shooting on the range and holding the gun and doing whatever I do with it there in person demonstrates competence, then that could, in theory, meet the standard of the statute. It doesn't require you to take a specific course. The courses are only a way that you can do it and not have to worry about whether the gun seller is worried about it. Is that right? Or worried the gun seller could tell you that's not enough. Isn't that pretty much how it's worded?
Mr. Chair.
Yep.
That is how I would read the language, since it does have the or, has demonstrated competence or completed a firearms safety or training course. And then as you pointed out, it says that proof shall include, so proof of any of those training courses shall be proof, but it is not an exhaustive list. That is how I would read it.
Right. So this bill does not require a course, just kind of strongly encourages one. Right?
Well, that is certainly the easiest way, I think. The clearest way to demonstrate competence is the statutorily provided methods, Mr. Chairman.
Right. Okay. Those are all my questions at this moment. And I think we're in the...
Thank you, Mr. Chair, for your legal expertise.
Yeah. Oh, I'm sorry. There's other people in the queue. I never pay attention to my queue here. I think this is all new technology for us, and I'm new at this job. So, Senator Subramanian.
Thank you, Mr. Chair. I'll just throw out a couple numbers since we're talking about numbers. One is I think already 9 states do this, I believe, and so far the constitutionality, I don't think it's been ruled constitutional so far. Maybe not. We can get some testimony on that. But the second thing is I think 81% of people in one survey said that they want this. I know I certainly would want it myself because I want to know that my neighbor has a firearm, that we're safe around them, and that they know how to use that firearm. They're competent with it. And then the third thing I'd say is that, we don't have statistics on this specifically, but in cases where states dropped concealed permit licensing in similar situations, so people didn't have to get training for that anymore. It was a 39% increase in gun violence there. And so I would say that training is important. I think it's something that this committee should consider. Thank you.
Okay, thank you, Senator Subramanian. Senator Obenshain. This mic keeps going on.
Mr. Chair, a couple of questions. Right now, if my 89-year-old mother wanted to buy her grandson a bird gun, a shotgun, she can do that, right? I mean, there's no prohibition as long as she's never been convicted of a felony, doesn't have some statutory bar.
To my knowledge, that is correct.
So, Mr. Chairman, are you telling me that under this, my 89-year-old mother would have to take a class or otherwise demonstrate her competency to use a shotgun in order to buy it as a Christmas present for my son? I mean, is that what this is supposed to do?
Absolutely.
It would?
Okay, make sure you speak into the mic. I can't.
Absolutely.
Okay.
So you want
Senator
my 89-year-old mother to demonstrate her competency even though she's never going to use it?
If she's purchasing it, it is her responsibility to know how to handle it. So yes.
even if she never intends to use it?
Senator Obenshine.
Intent is not a part of the bill. If she's purchasing it, then she needs to know how to use it.
Mr. Chairman, further question.
Senator Obenshine.
So if she chooses not to take a class or is physically unable to demonstrate her competency, she would be statutorily barred from purchasing the firearm. Is that right?
That would probably be correct.
Okay, thank you.
You get a gift certificate. Okay. I think we haven't taken anybody in support yet, have we? Or did we? Yeah, we have. Okay, looks like we got the
You've
opponents
taken
lined up.
support. You're waiting on opposition.
Okay, so yeah, why don't we check online for the opposition and those, and set the timer to 5 minutes, as we did for the supporters. Mr. Van Cleve.
Well, Van Cleve, VCDL, Maryland has had a law like this, and it was struck down by a court unconstitutional. So, and just because a lot of people want something doesn't mean you should override the Constitution. If 89% of the people said they wanted slavery back, I don't think we'd reinstate it.
And Mr. Van Cleve, sorry, just really, I'm not familiar with the Maryland case, but was that a law that required the class, or
to buy a handgun?
A law like this one that said the class is one way to demonstrate competence?
Mr. Chair, this required you had to take a specific course to be able to purchase a handgun. Now, this covers more than handguns. This covers rifles and shotguns. So up there was just a handgun, and it got struck down.
Right, but this one's also doesn't require a class. It just says a class is one way you can demonstrate. So this one's actually a little more permissive than the Maryland law. It seems the way you're describing it. I haven't researched it.
Yeah, it is, but on the other hand, it still would go back to, did we do that in history? We had to go step out in the back, and you're also assuming that there might be other ways they could show competence. And how would the gun store owner indicate the competence that he accepted for each individual person? I don't know. I just think it's constitutional and a lot of other problems with it. Thank you.
Thank you. Next, NRA.
Mr. Chairman, Taylor McKee from the National Rifle Association. And while we advocate for safety and training, we don't support mandating it. We'd oppose it because of the vagueness that we spoke about earlier, where it's demonstrated competency, and that's going to be a subjective call for the person selling the firearm. We also believe under the text, history, tradition standard, under the new Bruin standard, that this would fail under constitutionality. Thank you, sir.
Thank you.
Good morning again, Mr. Chairman. Patricia Webb, Virginia Citizens Defense League. A few things I would like to point out. Law enforcement is not required to undergo training per se. They're required to qualify, but they're not required to undergo training every 5 years or so. This bill, one of the training requirements was to have a concealed handgun permit, but the bill requires training every 5 years. Once you have your concealed handgun permit and you renew it, your training never expires. So there's a problem there. Also, this requires it to purchase, not to carry. So as the Senator Obenshine said, there's a big discrepancy there. This is very similar to requiring a civics exam before you're allowed to vote. So it would be like requiring a civics course every 5 years, or providing proof that you're proficient in history and the way our government works. And finally, leaving it up to the discretion of the firearm dealer. You have another bill in this body, I believe, that severely opens up firearms dealers to liability and civil suits. So that would have a chilling effect on a dealer saying, well, I know you shoot on a regular basis, so I'm going to sell you the gun. Then an accident happens. Finally, I would like to point out that VCDL is about safety. In fact, we have put together a safety pamphlet that we intend to make available to people that have firearms courses and to gun stores. And every single firearm that somebody buys has safety information included in it. If the body would like these, I would gladly share them with you.
Okay, thank you. Do we have any? We have a few more people. Do we have some people online as well that are going to be in? Opposite, two. Okay, there's two opposition online, 148 left. Go ahead, sir.
Thank you. I'm Al Evans with the VCDL. I strongly oppose the bill. I just like to echo the thoughts said about we should not put our rights behind competency tests. Like Pat said, that'd be similar to a civics or literacy test when it comes to voting, or even if it comes to journalism, and we should not have that. So strongly oppose the bill. Thank you.
Good morning, Mr. Chairman. Dennis O'Connor, Prince George. I appreciate the opportunity to speak on this since I have not demonstrated competency in my First Amendment rights, but I urge opposition to this bill. Thank you.
Hello, I'm Regina Payton from the City of Richmond, District 4, and I oppose this bill.
Okay, and there's nobody online, is that right? Okay, Senator Williams-Graves, you get the final word.
Thank you, Mr. Chair and members of the committee. I think that public safety is paramount here. I think that making sure that gun owners are responsible is our responsibility as legislators. And I would simply add that we make history every day, and circumstances in our Commonwealth and around the world change. And so the last thing I'll add is that if Senator Obenshain's 89-year-old mother wants to buy a gun to give it away, she might be accused of having a straw purchase. Thank you.
Okay, Senator Boysko.
Thank you, Mr. Chair. I would like to thank Senator Williams-Graves for carrying this bill. I think we all appreciate on this side of the aisle that, in just 2021, 1,428 people died from gun deaths, and that included 141 children. We've got to do something different, and I appreciate you bringing this forward, requiring firearm safety so that people who have guns in their possession actually know how to use them. My mom carried a gun for years in Alabama, and she would pick it up like this when she took it out of the car and bring it in. She did not have gun safety training, and I worried every day that someone was going to come and grab it out of her hands and use it against her. So this makes common sense, and I appreciate your effort. I have a motion to report the bill.
Thank you.
Okay, it's been moved and seconded to report the bill. Is there any further discussion? Oh, it is. Okay, I assume you want to go to finance, Senator Boysko? Yeah. Okay, Senator Boysko amends her motion. So it's report and refer to finance. No further discussion. We open the roll.
Ayes 9, no 6.
Bill reports and re-refers to finance. Thank you, Senator Williams-Graves.
Thank you, Mr. Chair and members of the committee.
So, Eben, I think you got 3, right?
I do, sir.
What do you want to do first?
Senate Bill 363 has to do with tampering with serial numbers on firearms. I think you've heard all 3 of these bills before, but I'll just give a brief overview. This bill would establish a Class 1 misdemeanor for a person who intentionally removes or alters the serial number on a gun, or someone who possesses such a gun, or someone who knowingly sells such a gun. We know that removing a serial number, while difficult, makes tracking down the weapon or tracking the weapon nearly impossible, and that guns without serial numbers have been used in a series of horrific mass shootings. Guns without serial numbers put law enforcement personnel in significantly more dangerous and difficult situations with untraceable and undetectable weapons. They work hard to ensure individuals pass background checks and are responsible gun owners.
Hey, Senator?
Yeah.
I think, do you have a substitute?
For 363, I'm not aware that, is council have a substitute on that one?
Oh, I'm looking at the wrong one for you. Okay.
Yeah, there's a different bill that has a
Never mind.
substitute.
Okay, keep going.
We know, anyway, it just is common sense. If you can't manufacture a gun without a serial number, you shouldn't be able to remove the serial number from a weapon.
Okay. Thank you, Senator. This is a bill we heard before. This is, what is this, 363? Okay. Is there any questions for Senator Evans? No questions. Okay. All those in favor of the bill Mike, MJ, we go 5 for 5, or? Okay. Come on up.
If anyone online would like to speak in favor of this bill, please raise your hand.
Good morning, Mr. Chair. Liddy Ballard from Brady. This is a pro-law enforcement bill. There's no reason why a law-abiding firearm owner would need to remove a serial number from a firearm, and Brady supports this bill. Thank you.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. We support this bill for the reasons given.
Gretchen Garber, volunteer with Moms and Men Action. We strongly support this bill.
Good morning, Lori Haas. We support the bill. Senator Eben is bringing a bill forward that would give Commonwealth's attorneys ability to prosecute these cases in a more robust way. Previous to this, it's been illegal to actually remove the serial number, and Commonwealth's attorneys have shared that they've been unable to prosecute those cases because they can't see or have zero evidence of a person actually taking an action to remove the serial number. This adds a possession prohibition of an unserialized firearm and gives a wider ability for prosecutors when they find these firearms at a crime scene. These firearms where the serial number has in fact been removed, they are able to prosecute in those cases because the person has possession. Thank you.
Thank you. Next.
Tanya Mallory with the Virginia NAACP, and we support the bill.
Okay.
Mr. Chair, there are two
Anybody
people online that would
two
like to
online?
speak.
Okay, please turn on your video cameras, identify yourself, and we've got 3 minutes.
Virginia, you may unmute and speak.
Virginia Roughneck with the Charlottesville Coalition for Gun Violence Prevention and the Charlottesville Center for Peace and Justice. This is an obvious gun safety proposal, and I strongly support it. Thank you.
Okay, who's next?
Ramin, you may unmute and speak.
Good morning, members of the committee, Mr. Chair. This is Rami Fadahi. I'm the Commonwealth's Attorney for the City of Norfolk. I'm here speaking in support of the bill on behalf of myself, the Commonwealth's Attorneys of the cities of Portsmouth, Charlottesville, and Fredericksburg, and the Commonwealth's Attorneys of Fairfax, Prince William, Arlington, and Albemarle County. We strongly support this bill, which would harmonize our laws with federal laws, specifically 18 United States Code 922K, that makes it illegal to possess a firearm with an obliterated serial number. This is very different from the unserialized firearm bills that the committee has considered before. This is the firearms equivalent of burning off your own fingerprints. Removing a serial number from a serialized firearm is a huge indicator of crime. It is frankly not illegal under Virginia law either to possess or to sell a gun in such condition. This is a public safety issue. It's come up in my jurisdiction. I would ask that the committee pass the bill, and my appreciation to Senator Evan for carrying it.
Okay, that's it for support. I want to reset the timer. All those opposed?
If anyone online would like to speak in opposition of this bill, please raise your hand.
Mr. Chair, Philip Van Cleve. Philip Van Cleve, VCDL. Yeah, this whole idea of requiring serialization, a federal judge in West Virginia, I think about 3 months ago, struck down an issue there dealing with serial numbers being required on guns. It's certainly not something we had in history. Before 1968, no gun was required to be serialized, so it definitely wasn't serialized in the founding days. Thank you.
Thanks. Mr. Van Cleve, this bill has an exception for antique firearms in it, right?
Yes.
It's defined in 18.2308.2:2. I can go look there if you want, Senator Stewart.
Mr. Chair, yeah, those are guns made before 1898. This is up to 1968. So there's a whole bunch of guns in there that are not antiques, but don't have serial numbers legally.
Got it. Thanks. You know more than I do on this. Okay, next.
Mr. Chair, Patricia Webb, I'm speaking as the owner of Gadsden Guns, and we are a firearms manufacturer. This bill also bans altering in any way, which would mean that somebody bringing their firearm for restoration or refinishing, you would have to mask off wherever the serial number is, making an ugly product. It just is not a practical bill. There are a lot of problems with it, in addition to what Mr. Van Cleve expressed. So we oppose this bill. Thank you.
Mr. Chair, there's no one to speak in opposition.
Thank you. Hey, Taylor, I got a question for you or Ms. May or Mr. Benjamin, one or the other, but I'm reading 18.2, whatever it is, 308.2:2. Mr. Van Cleve piqued my interest about the exception for antique firearms. It appears to me that statute says any firearm that's more than 50 years old, which uses a rimfire or conventional centerfire ammunition, no longer manufactured. Okay, so it doesn't include any firearm that's more than 50 years old, just certain firearms of a certain design that are more than 50 years old, I guess, would be considered antiques. Is that right?
Mr. Chair, I'm trying to pull up the definition, but I think that's correct.
Okay. Got it. Okay. Sorry. So, Senator Eben, you have the final word. For this bill that, reported 9-6 last year?
Yes. Yeah. It's just common sense. If you can't have a serial number, if you're required to have a serial number on a firearm, you shouldn't be able to remove the serial number. And people who remove serial numbers from firearms are not doing it for benevolent purposes.
Okay. Senator Stewart.
Thank you, Mr. Chairman. Senator Eben, you have limited your discussion to removing the serial number, and that was the way you just closed. But I'm reading this, and help me, because it says alter, change, I get destroy, I get obliterate, cause to be altered, changed. So typically, in my experience, and I don't deal a whole lot in handguns, but typically in my experience, if you've got shotguns, they either have bluing on them, which makes them that dark, shiny color, or they are painted now. A lot of people paint them camouflage. If I change the bluing or change the paint, have I not violated this statute under your bill?
I think the point of the bill is that you have to be able to see the serial number, and you can't alter the serial number. And
Mr. Chairman,
that should be protected.
Senator Stewart.
But that's not what it says. I asked counsel. I mean, it says change, alter. Remove, destroy, obliterate are different.
Yeah.
But change and alter.
The serial number itself should not be changed or altered under this bill. That's correct. The serial number itself, not the weapon, but the serial number, needs to be visible and not altered.
But, Mr. Chairman,
Senator Stewart,
if the bluing is gone on the gun, and I have someone put new bluing on the gun, I've changed the serial number. Likewise, if I paint it a different color camouflage, I've changed the serial number.
Don't paint over the serial number. Let the serial number be read, and let law enforcement have access to that information that is designed to be traceable.
Okay, thank you.
Senator Eben, are you done?
Yes, sir. Thank you.
Senator Obenchain.
So, just to follow up on Senator Stewart's questions, line 64 through 66 says it's unlawful to transfer ownership of any firearm that is not imprinted with a valid serial number.
The bill I have has 37 lines.
Yeah, my apologies.
Yeah, this one only has 37 lines in it.
Yeah, it's only 30.
Yeah, I'm sorry.
37 lines. You want to see it?
I got it.
I think you're probably on Ghost Scout.
Yeah.
Next one. Yeah. Okay.
Coming to that one.
Any other questions? Okay, the proper motion be to report and re-refer the bill to finance.
Second.
It's been moved and seconded. Report and read for the bill to finance. Clerk, open roll.
Ayes 9, no 6.
The bill reports and refers to finance. Senator Eben, you've got two more ghost guns and open carry of assault rifles, I think.
The next one is Senate Bill 100, the Ghost Guns Bill, and there's an amendment in the nature of a substitute with some technical clarifications.
Okay, is there a motion we adopt the substitute? So moved and seconded we adopt the substitute. I didn't hear. Is there a second? Okay, I guess there's a second. All those in favor say aye. Aye. Anybody opposed? Opposed. The substitute's before us.
Okay.
Being distributed.
Okay, the provisions of this bill would apply to a firearm that after the removal of all parts other than a major component is not detectable as a firearm when subjected to inspection by the types of detection devices, including X-ray machines that you see at airports, government buildings, schools, correctional facilities, and other locations for security screening. It would be a Class 5 felony for someone to knowingly manufacture, assemble, import, purchase, sell, or transfer, or possess what we call a ghost gun. Under current law, it's unlawful to manufacture, import, sell, transfer, possess a plastic firearm, but this widens that a bit. We're fixing a loophole. Manufacturers are required to put a serial number on finished firearms, but not on individual parts. This bill only addresses unfinished frames and receivers, and the process of converting these parts, which can be purchased without a background check, license, or record of sale, into a ghost gun involves just a few steps and can be completed without any specialized skill. There are websites that advocate for this. Ghost gun kits include all of the traditional component parts to turn the unfinished frame or receiver into a fully functioning gun that looks, feels, functions like a traditional gun, whether a handgun or assault-style weapon, and it's just as deadly or dangerous in the wrong hands, except the people who would buy these kinds of weapons include people who might want to avoid a background check, like a domestic abuser, a minor, or a violent felon. They can get access to these weapons, and this would limit that. We know that ghost guns have been used in some horrific mass shootings. I'm just going to mention two of them. In 2017, a man under prosecution for multiple crimes killed 6 people and injured 10 in Rancho Tehama Reserve, California, with 2 assault-style rifles he assembled using parts ordered online. And in late 2019, a 16-year-old used a ghost gun to kill 2 students and injure 3 others at Sagas High School in California. He was too young to legally purchase a gun. The measures in this bill do support legitimate gun sellers who can lose business to those selling these parts and kits that are marketed as unregulated and untraceable. We know that serial numbers are key, as I explained in the last bill, to firearm tracing and law enforcement investigation. It's hard to scratch them off, and it's illegal, a felony to do so. I know that in 117 handguns were caught at Virginia airports in 2023, including 5 at Roanoke-Blacksburg Airport, according to the Roanoke Times, but the 6,737 detected at airport security checkpoints nationwide, 2023. That's the ones that were detected. And these guns, some of them are undetectable. It's just, if you want to buy a gun, be authorized to buy a gun. Don't put one together of these kits that are marketed to people who would otherwise not be able to legally possess a gun. And that's the bill.
Hey, Senator, for the maybe half of us who were here last year who heard this bill, I assume the substitute had some changes compared with last year. What do you know what those are?
There were technical clarifications from the introduced bill, but I'm not sure what if there were any substantive changes from last year. I don't know if Council would remember it, but I do not know which the changes were.
Taylor, do you know? Sorry.
Mr. Chair, I can find out, but it'll take me a couple minutes.
Okay, Senator Boysko.
Mr. Chair, I remember a few years ago, I think it was the first time, maybe in 2020, when Senator Eben brought a similar bill to this. There was not a provision that protected the federal law enforcement officers at that point, and I know I'm glad to see that language is in here now. I think that everybody should be able to support this bill. That was a problem last time.
And that's on line 92 of the substitute, Mr. Chairman, but federal, local, or state law enforcement or federal firearms importer or federal firearms manufacturer who are doing this in the scope of their employment would be protected.
Yeah, we've been discussing this over multiple sessions. Sorry. Yeah, we've been discussing this over multiple sessions and getting, I think, a finer and finer product here. But any other questions for Senator Eben? Senator Obenshain.
Mr. Chairman, now that I'm looking at the right bill, I would direct your attention to lines 64 through 66. So I live in rural Virginia. A lot of people do have old shotguns and old firearms that may not meet the classification of antiques. I know that I inherited an old shotgun from my grandfather. I'm pretty darn sure it's an old side-by-side, sat in a closet for probably 60 years, and I'm pretty sure it has no serial number on it. A lot of people have multiple guns that they leave to their children, grandchildren, distributed through estates, or may gift those guns before they die. As I read this, if I were to give those guns to multiple of those guns to my children, they are firearms that are not imprinted with a valid serial number. I'd be guilty, I think, of a Class 4 felony. Is that your intent?
So would your children.
Oh.
Senator Eben.
And my children.
Well, the way I read this in terms of transfer ownership is my understanding is that dealers will serialize a firearm if required, so that would be one option, would be that you could get a serial number imprinted.
I could get a serial number for my gun? Or for
That's
these
my
old
understanding.
shotguns?
My understanding is that you can.
From whom?
From a dealer.
Senator Obenshain. Senator Babbitt.
Well, we're targeting more than the finished guns, the parts and kits used to build them. But I take your point and point out that if you wanted to transfer a gun without a serial number, you could get it serialized.
Thank you.
Okay. Are there any other questions from the committee? No.
Mr. Chair.
It's usually a hot one. All right, Taylor. Ms. May.
I did look up the bill that this committee heard last year, and last year's bill didn't address the plastic firearms or undetectable firearms. It only created the new section for the unfinished frame or receivers, and it also, I think, only added the section making it unlawful for someone to sell, offer to sell, transfer, or purchase, and didn't include all of the procedures for how you might go about getting a serial number. So there are a number of changes from the bill last year.
So I think that addresses Senator Obenshain's concern. So this appears to me like, I guess, on line 73,
maybe,
where it says you can get a firearm serialized. Is that right? I'm not going to say whether it addresses concern, but at least line 73 and down talks about how you can get a serial number put on a unfinished frame or receiver, right?
That is correct, Mr. Chair. It does provide for how an FFL may serialize a firearm. And I apologize, I did miss the interaction, and I'm not sure if this applies to the question from Senator Obenshain, but I did want to point out that something that was added in the substitute was an exception. It's on line 98 of the substitute that has an exception for firearms manufactured before October 22nd, 1968, which is the date that the Gun Control Act was passed, and firearms were not required to be serialized before then. I don't know if that also addresses the question, but wanted to point that out in the substitute.
Okay. Thank you, Ms. May. Senator Stewart.
Thank you, Mr. Chairman. And so, based upon that discussion and the fact that you can get a serial number on it, I'd ask, I'd ask staff, is there anywhere in here that provides an affirmative defense to these crimes if you are on your way to get the serial number put on the gun when you get stopped? Or are you just a criminal until it actually happens?
Mr. Chairman, Senator Stewart, there is no affirmative defense.
Thank you.
Okay, any other questions for Senator Evan? No other questions. Okay. Mike, MJ, let's go 5 and 5. All those in
If anyone
support.
online would like to speak in favor of this bill, please raise your hand.
All right, support, come on up.
Good morning, Mr. Chair. Lydia Ballard from Brady. To reference a couple of the questions, 6 months after enactment were this bill to pass, there is a 6-month period to come into compliance with the law. Most FFLs have the capacity to serialize at this time. That was a requirement under the federal law. And so there is that window built in to, for the examples given, take existing firearms that are not serialized and come under compliance. The last thing I'll say is that ghost guns circumvent nearly every single gun violence prevention law that this state has worked hard to pass, and there's no reason why unserialized firearms need to be in the hands of responsible firearm owners. We strongly support this bill. Thank you.
Hi, my name is Melissa Flynn. I'm a volunteer with Moms Demand Action, also the parent of a Henrico County public school student, which recently put in metal detectors to enter the school. I strongly support this bill.
Talia Mallory, the Virginia NAACP, and we support the bill.
Good morning, Lori Haas. Mr. Chairman, members of the committee, we strongly support the bill. This just requires parts to be serialized so that when these parts are made into a fully functioning firearm that is used in a variety of ways, often illegally and often found at crime scenes, that they have a serial number on them so that law enforcement can trace the firearm. It's a simple, common sense bill. It has some exceptions for antiques, those built before 1968. It also requires the FFLs to have the ability to, federal law recently has passed rulemaking that is going to require FFLs to have the ability to add serial numbers because this is such a problem for law enforcement. Ghost guns are found far too often at crime scenes. We fully support the bill. Thank you.
Mr. Chairman, Andrew Goddard speaking for the Virginia Centre for Public
I heard a
Safety.
noise. Oh,
we support the bill
Sorry,
for all the reasons.
Mr. Goddard, I interrupted you. I didn't hear what you said. Okay. Although, is there anybody online? 2 online.
Mr. Chair, there are 2 online.
Okay.
Janine Curtis, you may unmute and speak.
And turn your camera on.
I'm sorry. Mr. Chairman and members of the committee, my name is Jean Hanowich from Chesapeake, Virginia. I'm speaking on behalf of the League of Women Voters of Virginia in support of this bill. Ghost guns make it easy for prohibited and dangerous individuals to evade federal and state gun regulations and create a dangerous loophole. Please vote yes. Thank you for your time.
Virginia, you may unmute and speak.
Virginia Rosnack, Charlottesville Coalition for Gun Violence Prevention, the Charlottesville Center for Peace and Justice. For all the reasons given by others, I support this bill. Thank you.
Mr. Chair, there are no other speakers online.
Great. Can we reset the timer?
Mr. Chairman.
Senator Stewart, you have a question for somebody?
Yeah, I have a question and a thought for Senator Evan. In listening to Senator Evan and then Ms. Haas came up and talked about this, it appears to me that the concern here is people using, generally I think handguns, but certainly other guns in crimes. And so if that's what we want to get at, why don't we just make it a Class 5 felony if you use one of these guns committing a crime? My concern is you have a lot of honest people out there who do not intend to violate the law, but could get trapped up in this unwittingly and unintentionally. So if we want to go after the criminals, then let's go after the criminals and say it's a Class 5 felony if you use one of these in the commission of a crime.
I think that we want to prevent them from proliferating because we can't know in advance exactly which one will be used in a crime. And when you heard from the prosecutors who support this bill that they find them at crime scenes, they need to be traceable. It's harder to find out whose gun it was without a serial number after the fact if you find it at a crime scene. There's no tracing of it. So we need more weapons to be traced in general, regardless. Federal law requires that guns that are assembled have serial numbers. We think the guns you put together yourself should also have a serial number. There shouldn't be two different standards.
But, Mr. Chairman, if we're trying to get at the criminals who are committing crimes with guns, then let's direct this at the criminals, the people who are committing crimes. That's where I'm having a hard time.
Most law-abiding gun owners
bills.
don't have any problem having a gun with a serial number, Mr. Chair. And I would say that this doesn't impact the vast majority of gun owners. And the people who go to these websites like ghostgun.com that are marketed to people who couldn't pass a background check, like domestic abusers, minors, or violent felons, should not be having easy access to buy the weapon in the first place. And having a serial number is a way to trace it if it should be used. Without that serial number, I don't know how Senator Stewart is going to find who used that weapon if it's just at a crime scene with an untraceable number.
But, Mr. Chairman,
Go ahead.
aren't we going to end up catching up honest people who did not intend to break the law and who, in fact, are not committing crimes by them simply possessing these? And so shouldn't we do something to protect honest people who are not intending to break the law? Why don't we go after the criminals instead?
Mr. Chairman, if I might, I would like to see us protect the Virginians who are losing their lives at a pace of about 3 a day to gun violence, including people who are should not have access to a weapon, and the lack of having these numbers makes them untraceable. I just disagree with Senator Stewart's premise that most of the people who are law-abiding citizens who purchase a gun should have no problem with a serial number making that weapon traceable for law enforcement, should it need to be traced.
Okay, any other questions for Senator Eben? Okay, we think we're done with all the testimony, right, MJ? Huh? Oh, we haven't done opposition yet? Okay, let's reset the timer.
If anyone online would like to speak in opposition of this bill, please raise your hand.
Philip Van Cleve, VCDL. We oppose the bill.
Chairman Taylor McKee from the National Rifle Association. I'd just like to point out the plastics portion of this bill is already covered on the Undetectable Firearm Act. As far as the frames and receivers go, there's a long history and tradition of Americans making their own firearms. And that even though this is an administrative rule, it's currently under litigation and being challenged in the courts now. So, thank you, sir.
Thank you.
Good morning again, Mr. Chairman. Patricia Webb. I'm speaking on behalf of Virginia Citizens Defense League and as a licensed federally licensed firearms dealer. Currently, federal law requires firearms manufactured commercially to be serialized, and they are there is a registration system through the FFLs. When Congress passed this law in 1968, they deliberately excluded privately made firearms from that, and they deliberately excluded private sales from the background check system later when the Brady Act was passed. The reason for this was to prevent a gun registry, because we all know that registration leads to confiscation. The FBI has, and in their reports, they have shown that trace data almost never leads to solving the crime. So requiring the serial numbers as a means to solving the crime is a rather moot point because it's ineffective. The way that the trace data works is it takes you back to the last owner that purchased it from the FFL. It was mentioned earlier that most dealers are capable of serializing the firearms. That's simply not true. The equipment to do this costs thousands of dollars, and it takes quite a bit of time and a learning curve. I know because I own a laser engraver. It was over $5,000 for something that would engrave firearms. And the innovation was mentioned by my colleague from the NRA. I would like to point out that because of homemade firearms and because of the innovation that is promoted by that, we have safer firearms today than we had 50 or 100 years ago. So you would be actually preventing safe innovations by passing this bill. So I urge you to pass it by. Thank you.
Hello, I oppose this bill. Bye-bye, thank you.
Mr. Chair, there is no one else to speak.
Okay, no one online. Close the testimony. Oh, wait. No. Okay, Senator Evan, you get the final word.
Yeah, just to comment on one of the things one of the witnesses said. When law enforcement finds a gun at a crime scene, the first thing they do is trace the weapon and see who the last known possessor was or purchaser. If they don't have a serial number on the weapon, then it becomes a cold case without the same prospects of solving that crime. And that I would say Congress is not always right. If they made a mistake, we don't have to abide by it for all time.
Okay.
Move the report and we refer to findings.
Okay, it's been any further discussion? Okay, it's been moved that we report and re-refer the substitute to the Finance Committee. All those, or open the roll, please.
Ayes 9, no 6.
Seems to be the theme of the day, Senator Eben.
Yeah, I've got one more, sir.
You're into finance. Last one, this has to do, I think, with open carrying, right?
Yes, this is SB 99, a ban on the public carry of semi-automatic assault weapons. We know that under current law, the prohibition on carrying certain shotguns and semi-automatic centerfire rifles and pistols applies to a narrow range of firearms only in certain localities and only when the firearms are loaded. And in terms of public safety or panic or that sort of thing, these weapons can be frightening to folks. There was an effort in Alexandria a few years ago to carry them at the farmers market. I think you're familiar with that, Mr. Chairman.
Yeah, my son was there.
We know that these are, the weapons are defined in the bill. The assault-style weapons are defined as a semi-automatic centerfire rifle or pistol that expels a single or multiple projectiles with a fixed magazine capacity in excess of 10, or there's a longer definition of semi-automatic centerfire rifles or pistols that can accept a detachable magazine that has certain characteristics, or a shotgun with a magazine that will hold more than 7 rounds of the shortest ammunition for which it's chambered. The prohibition on public carry does not apply to law enforcement officers or military personnel in the performance of their duties or any person engaged in lawful hunting or recreational shooting at an established shooting range or shooting contest. We know that semi-automatic assault weapons make mass shootings deadlier. Our review of mass shootings between 2009 and 2015 demonstrated that in shootings where assault-style weapons or large capacity magazines are used, 155% more people are shot and 47% more die compared to those without them. We know that semi-automatic assault weapons are used in the majority of mass shootings. And during the 10-year federal assault weapon ban period, both the number of gun massacres and the number of people dying from gun massacres decreased significantly by 37% and 43% respectively compared to the 10-year period without the ban. We can open concealed laws, increase gun violence in multiple ways. They allow individuals who have a history of acting violently to carry their firearms in public. They promote a shoot-first culture of violence, and they encourage armed intimidation, as we've seen before. And they complicate law enforcement's response to potential threats. I would hate to be a police officer and have to walk up to a group of people carrying these type of weapons and say, can I see if the gun is loaded or not? And the people at the farmer's market or other public gatherings don't know whether the weapon's loaded. And due to many states' weak public carry laws, far too often extremist groups have used military-style weapons to intimidate and suppress the rights of others wishing to express their views. We saw that at Unite the Right in Charlottesville, and public carry of assault-style weapons complicates law enforcement response to potential threats and hampers the reaction to active shooters.
Senator Evan?
Yes.
I think Senator Stewart has a question, but I just want to note for the committee and those online that none of us can seem to pull the bill up online right now on LIS. LIS seems to be down. So for those of us that try to be electronic, we're having a hard time actually seeing your bill. Senator Stewart.
Thank you, Mr. Chairman. And that's why I have a question, because I'm unable to actually read the bill. But based upon the description, you're prohibiting pretty much everything.
Semi-automatic.
Shotguns, semi-automatic shotguns,
right?
Anywhere that it's open to the public. So Game and Inland Fisheries has a lot of public hunting land in Virginia. This bill would prohibit you carrying the shotgun on the public hunting land, if I'm reading the description right, but I can't read the bill.
There's an exception for people engaged in lawful hunting or recreational shooting at an established shooting range or at a shooting contest. So if you're hunting, it's not. If you're lawfully hunting, it does not apply to you.
So, Mr. Chairman, it would be your intent. It would be your intent that it not apply to public hunting land in Virginia.
Right. Line 50 of the bill, current law, says any person engaged in lawful hunting or lawful recreational shooting, that's okay for them. But what we're trying to get at is we don't want where there's a lot of people, for people to be walking around openly carrying these weapons. They can not display them and be walking through inducing panic among people who don't need to be unduly panicked.
Is the bill up now? Thank you.
Sorry, it's back
I
up
have
now,
a copy
Senator
here if
Stewart.
you want to borrow mine.
It's back up now. Senator Deeds.
Mr. Chair, I just say that language, that language exempting hunting is mostly existing language on lines 48 through 50. 50, and there's new sentence added, but it says it exempts people engaged in people actually engaged in lawful hunting or lawful recreational shooting activities at an established shooting range or shooting contest. That's existing language. That's on lines 48 and 49, 50 and 51.
Okay, are there any other questions for Senator Evans? Senator Obenstein.
Mr. Chairman, I would ask, does this not run just absolutely contrary to the Supreme Court's holding in Bruin by designating all public areas as essentially sensitive areas? I mean, the Supreme Court in Bruin held that you can't designate Manhattan as a sensitive area. You're seemingly designating all of Virginia as a sensitive area.
This is only, Mr. Chair, this is only for certain kinds of weapons. But I don't have the Supreme Court ruling in front of me. Perhaps some of our witnesses will be able to comment better than I on that. But this does not say that you can't carry a weapon. It says you can't carry certain weapons.
What if it's the only, Mr. Chairman?
Senator Obenstein.
What if that certain kind of weapon is the only weapon you own?
Then you can't openly carry it in those areas, Mr. Chairman.
so you must conceal it.
Senator Obenshine. If you're allowed, if you have a permit. And stuff that AR-15 in your jacket.
Mr. Chairman, my point is that, you know, we've had robust discussions over the years about state laws that are plainly contrary to Supreme Court rulings. And I just would submit that this is in direct conflict with the precedent established by the Supreme Court in New York, Rifle and Pistol Club versus Bruin.
A question for counsel, either Taylor or Steve. My recollection of Bruin is that it had to do with, I think, handguns, first of all. But secondly, this bill only applies to guns that would meet the definition of a, or at least with the semi-automatic rifles, you have to have folding telescope, collapsible stock, magazine below the pistol grip. I mean, it also applies to a couple other guns, but on the semi-automatic rifles, that's what it applies to, right?
Mr. Chairman, my recall about Bruin is that it involved a New York statute that required that a person applying for a concealed weapon permit show proper cause or show a need for that as opposed to the generalized public. That statute was struck. Your second question is, Mr. Chairman, yes, this bill deals with specific types of firearms.
Mr. Chairman.
Okay, Senator McDougal.
Just looking at lines 16 to 19.
Right.
Is there any law enforcement department in the Commonwealth that carries a handgun that has less than 10 rounds?
Who are you asking it to? Okay, Senator Evans.
I just point out that on line 48, this does not apply to law enforcement officers or military personnel.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, I think my question was more to make the point that almost every handgun that is not a revolver has a clip that is greater than 10 rounds. So if the law enforcement officer is in uniform displaying a badge of authority, certainly that wouldn't be applicable. But as soon as they're off duty, and there's a lot of case law out there indicating that off duty could be when their shift ends, then that would be different.
Okay, Senator Abbott.
Yeah, this is for law enforcement officers in the performance of their duties. So point taken, but what we're trying to get at is not law enforcement officers, but people who are carrying these types of weapon in public, causing panic. That's what we're trying to get at.
Mr. Chairman.
Senator Perry.
Line 48 actually says the provisions of the section shall not apply to law enforcement officers. It actually doesn't specify whether on duty or not on duty.
Oh.
We do see that in other sections.
Well, it says in performance of their law.
No, actually, line 49, where it says in performance
Actually,
of their duties.
comma, military personnel in the performance of their duties, so that would apply to military personnel, not to the law enforcement officers, which could or could not be right, but in response to the question, I think the answer is it's just law enforcement officers.
Yeah, you're probably right about that.
Thank you. Thank you, Mr. Chairman. I appreciate that. I'll take it.
Yeah. Okay. Are there any other questions before we go to testimony, for and against? Okay. We set the timers to 5 and 5.
If anyone online would like to speak in favor of this bill, please raise your hand.
The chairman's not available. Mr. Chairman.
Goddard. Yes.
Andrew Goddard, Virginia Center for Public Safety. We support the bill. I point out that this restriction already exists in many localities around the Commonwealth. This is simply an expansion of that. These weapons that we're talking about are often the weapon of choice for mass killers. They're also the weapon of choice for cosplay soldiers who are forming private armies all around our Commonwealth. And that is a very intimidating thought.
Good morning, Mr. Chair. Liddy Ballard from Brady, and I'm a Richmond resident. Virginians should not have to feel intimidated or in fear when they're at the farmer's market or in a park. There's simply no reason that anyone other than law enforcement or the military needs to be carrying a weapon of war in places of peace. Brady urges support of this bill. Thank you.
Thank you, Mr. Chair. My name is Melissa Flynn. I'm a volunteer with Moms Demand Action. Strongly support this bill.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. We are definitely in support of this bill. Seeing semi-automatic assault-style rifles being carried down the street on the sidewalk in front of my home on Monument Avenue is very disturbing. It's uncomfortable, and the persons are there to intimidate the public. They're there to intimidate law enforcement. They're there to make a statement, and we find it unacceptable. I'd also like to point out that there are semi-automatic assault-style rifle bans in many states across the country, and in effect, the result of that ban means that persons can't carry those openly or in the public at all. So we support this bill. And then lastly, I believe that Bruin was addressing a concealed carry situation of a person applying for a concealed carry permit. It didn't expand on or comment on open or public carry. Thank you.
Talia Mallory with Virginia NAACP. We're in support of the bill. Earlier this year, a concerned citizen from Spotsylvania County called our election protection hotline, and she was concerned that she saw armed security guards at her polling precinct who were being very, very vocal about who they wanted to vote for. And so for those reasons and many others, we support the bill.
Okay, is there anybody online?
Aaron, you may unmute and speak.
And turn on your camera.
Good morning again, Mr. Chair. My name is Erin Earp, again with Giffords Law Center. I just wanted to emphasize that a number of courts have upheld assault weapons bans across the board, public carry, private possession, and to flag that most recently the Seventh Circuit upheld Illinois' assault weapons ban, and the Supreme Court back in December denied 2 requests to block enforcement of that ban while the case is being litigated. So there is substantial evidence that bans across the board are constitutional post-Bruin. So thank you for that.
Virginia, you may speak.
Virginia Rovnak, Charlottesville Coalition for Gun Violence Prevention, the Charlottesville Center for Peace and Justice. These rapid-fire weapons are extremely intimidating, and they would clear areas of people. Somebody walking around like that, they have no business hanging out near a voting location. I strongly support this bill. Thank you.
Clear the timer, and all those opposed, come on up.
If there's anyone online that would like to speak in opposition, please raise your hand.
Mr. Chairman, Philip Van Cleve, Virginia Citizens Defense League. I think in California, a judge struck down their assault weapon ban. The reason the Supreme Court has opted not to step in on this is they don't like to interfere with cases that haven't truly worked their way up to them. They had a few cases that came to them where they were trying to get them to make a judgment ahead of time, and they just don't typically do that. It doesn't mean that they agree with the assault weapon ban when it finally gets to them. You can't conceal carry a long gun in Virginia. So it's not like that's a magic option. Well, you can have your gun, but you just have to conceal it. You can with a handgun with a permit. There's no provisions for long guns at all. It also mentions any place open to the public of whatever nature. Well, so a gun store, can't have a visible assault rifle in there. So that's really broad. And panic. I've yet to actually see any panic from people carrying these guns. We had thousands of people out here in 2020. I didn't see panic anywhere. Thank you. Opposed?
Thank you. Who's next?
Mr. Chairman, Taylor McKee with the National Rifle Association. We oppose this bill. There seems to be some confusion on Bruin. It did away with, it was about pistol permit purchases or permits for handguns in New York, but arguably the most important thing that came from it was that it's now a single test instead of dual test, where if it touches the Second Amendment, then you use a tiers of scrutiny test. That is now gone, and we're using text, history, tradition anytime it comes up onto the Second Amendment. And while it didn't explicitly go over sensitive places, there were some enumerated in the Heller and Bruin decision, those being legislative offices and courthouses. The theme there seems to be where any time the government fully takes that burden on controlling egress, entrance, providing security, then that might be allowed to be a sensitive place. These places listed in the public would not conform to that. And also we're saying there's certain weapons that won't be taken, not all of them. Under these new definitions, it seems to take away most pistols these days because they have 10 rounds or more. In addition, most are manufactured coming from the factory with the ability to have suppressors and all this screwed on. And for shotguns, we've changed the definition to hold the shortest ammunition possible. And now we're going from 3.5 inches shell, which was the previous definition of longest, and going to mini shells, which can be an inch or inch and a half. So effectively banning most of these guns, and for these reasons we oppose, Mr. Chairman. Thank you.
Good morning, Mr. Chair. Patricia Webb, Virginia Citizens Defense League. We've heard a lot this morning about people that are afraid when they see somebody carrying a gun. And some have stated that they have the right to not be afraid. Frankly, that is an unreasonable expectation. There are lots of scary things in the world, and fear is a healthy emotion. There are brandishing laws that address people who carry and display firearms with the intent to intimidate. So we already have laws on the books that cover that. I would wager that there are a number of people that are afraid to come up here and speak against this bill today. Should we outlaw the right to redress, the right to voice our opinions because people are afraid of it? My grandmother had a traffic accident. She was deathly afraid of vehicles after that and of traffic. We did not outlaw cars. We did not ask for cars to be outlawed. And as far as having guns in public in relation to the Bruin and case history, we had militias that practiced on our greens in our cities with firearms. And militias are one of the protected classes, not just in the federal Constitution, but in our Virginia Constitution. So I urge you to defeat this bill. Thank you.
Ms. Webb.
Yes.
Let's have a question for you based on that. And I know you weren't at the city of Alexandria the day that Senator Eben referenced when I think it was 3 men drove up from, I want to say it was Prince George, I think, with AR-15s and decided they wanted to just walk around the Alexandria Farmers Market. And you know the reason I know about it is my father and my son were there. They go there every Saturday. It's something they always do, and they came back and I heard about it. I heard about it many times from my son. It was not a pleasant experience for him. What do you think the purpose is of going to just driving, an hour and a half, 2 hours, other than to try to intimidate and scare people, driving 2 hours up to a locality which is known for its firearm positions, which are different from yours and other parts of the state, to walk around with an AR-15 with a lot of people trying to buy ham biscuits and vegetables? What's the point?
Mr. Chairman, I would say I do not pretend to know what is in someone else's mind. I am not a mind reader. However, our law enforcement are equipped with certain psychological training in the line of their duty, and they are able to talk to the people and ascertain if they are there with the intention of intimidation or with the intention of picking up said biscuit.
Okay, well, just appreciate your testimony.
Thank you.
We'll debate this more, I'm sure, later. Next up.
Hi, my name is Al Evans. I'm with the VCDL. I would strongly oppose this bill. I would like to, again, kind of reiterate what I was saying earlier about the fact that we're gatekeeping rights when we're talking about the Second Amendment, especially in public areas. I would also say that this law is very similar to kind of the famous law that dealt with the Black Panthers, which you may call as a militia or anything like that. The fact of the matter is that we do have the right to carry, and you shouldn't take that right away from us. Thank you.
Thank you. 14 seconds over, not your fault, but...
Hello, I'm Regina Payton from District 4 in the city of Richmond. I was here for the 2020 Lobby Day. It was the most beautiful sight that I've ever saw. That many guns in one area. It was gorgeous. It made me very proud to be there, happy to see. And I felt safer there than with the drones that's been flying over the city of Richmond. Bye-bye, thank you.
Mr. Chair, there's one person online.
Okay, one person online, you turn on your camera and just say who you are, and if you represent somebody, who you represent. We're now a minute over on the opposition.
Hey, Steve Birnbaum, I live in Ashburn. I represent the Jewish community. Open carrying of weapons for intimidation affects us as well. However, we also rely on these same weapons for our security. Jews have been terrified, especially since the massacre of October 7th. The FBI's own research finds that 10 rounds will not be sufficient to stop and deter the attacker. Public spaces can include synagogues. We have rifles within our synagogues in many cases to protect against attack. I ask if there's a more nuanced approach that can be found that doesn't limit our magazine capacity to stop threats, that doesn't limit our ability to provide security in our synagogues, but that can still address the open carrying for the purpose of intimidation. Thank you.
Thank you for being brief. Senator Eben, you have the final word.
Yeah, I said earlier that public carry of assault-style weapons can complicate law enforcement response to potential threats and hamper reaction to active shooters. And I just want to give one example. In open carry states, officers can't intervene with potentially fatal consequences. In Colorado Springs in 2015, residents called 911 to report a man walking around with a semi-automatic AR-15 rifle. A dispatcher told the woman who called, well, it's an open carry state, so he can have a weapon with him or walking around with it. And then that gun carrier went on a shooting spree later that day, killing 3 people. This bill does not ban assault weapons, rather it bans open public carry, but it does have ability for owners of these powerful weapons to practice at a gun range or engage in lawful recreational shooting. I think that strikes a fine balance, although I personally would rather not see these weapons at all. Even if we ban them, those that exist now need to be limited in how they're used in public. And there are 4 states that prohibit open carry entirely, and 9 states require a permit to even open carry a handgun. So this is not total new ground that we'd be breaking.
Okay, Senator Obenshain.
Mr. Chairman, if I may, a couple of observations about the bill. I've heard from the patron and numerous of the supporters what the intention of this bill is. The intention is to stop people from scaring folks in public. I actually happened to be in Alexandria one of those days where folks were walking around with ARs and I didn't notice any particular panic, but I will point out that I find it difficult to believe that that is really the intention here without meaning to question the motives of the patron, because at lines 51 to 52, it says that the provisions of this section shall not apply to a firearm that has been rendered permanently inoperable. So you got a AR-15 that is has been rendered permanently inoperable, there's nothing to prevent you from walking around the public square with that weapon, even if it subjectively is disturbing to people. So I set that aside and dismiss that as the real intention here. What this does is it prohibits people from carrying operable AR-15s. There's no way that people have any ability to, or any long rifle, no way that anybody has any ability to make that determination as to a rifle that they see. Second of all, Bruin, I would respectfully submit, renders this just categorically unconstitutional. Bruin did deal with handguns, but it dealt with the public carry of handguns in public places. The holding of Bruin is not restricted to handguns. It is addressing weapons generally, and even the state of New York, which was defending its laws, conceded that the Second Amendment guarantees a general right to public carry. The thrust of the argument by the state of New York there was that there are these sensitive areas in which you should not be allowed to publicly carry, and essentially they designated the entirety of Manhattan as such a public area. This runs completely contrary to that, in that it declares all public areas except for hunting areas and rifle ranges as sensitive areas. So I just respectfully submit that this just runs completely contrary to the holdings of the Supreme Court. And if we're going to abide by the holdings of the Supreme Court in certain areas but not others, I just would question the wisdom of doing so. Thank you.
Thank you, Senator Obenshain. Anybody else? No, I would just note, from what I've been able to glean online quickly, is last year we had, I think, it was either a record for mass shootings or the second highest year on record. I think it was over 600 reported, I think, or maybe over 700. But we have had several in Virginia. I know we had Virginia Beach. We had the Walmart shooting in Chesapeake, UVA, where my daughter attended. There was a shooting that occurred there. And while carrying around a AR-15 in public might not cause people to run, that doesn't mean it doesn't cause people harm. And I know that a lot of people in this country and in the state today are on edge because of all the mass shootings that have been happening. And when people see these firearms in public, they might not react in a way you can see it physically, but it affects them. And I can tell you that, speaking to my daughter, there's a lot of kids at University or that were at the University of Virginia that are still in therapy because of the shooting that happened on that campus and the lockdown they endured for the 12 hours they were there in lockdown. So just because people don't run doesn't mean there's not harm. So I think this bill will probably continue to evolve as it moves through the system. I think it has to go to the Finance Committee. Is there a motion?
Move to report and re-refer to Finance.
Okay, it's been moved and seconded that we report and re-refer the bill to Finance. Does anybody else have any discussion? Clerk will open the roll.
Ayes 9, no 6.
Thank you, Senator Evan.
Thank you, and thank you to the members of the committee for their time and their vote.
Great. I think Senator Marsden is the last non-committee member bill that we have on the docket for today. Senator Marsden, we have 447, which I believe we heard last year, if I'm not mistaken, right?
Sorry, Mr. Chair.
A lot of new committee members. We heard 447 or a version of it last year, right? We heard your bill last year, right?
Yes, this is a different version of that bill. The bill last year dealt with cars being left in unlocked vehicles, which
guns being left in unlocked vehicles.
Yeah, this one, this bill deals with a handgun being visible in an unattended vehicle on a public highway or public property, and it leads to basically a traffic offense, a fine of up to $500, and the fact that the car would be could be determined by the police to be illegally parked and have it towed. This is a minimalist approach to dealing with a huge problem. Those of you on the Crime Commission, Mr. Chairman, probably remember this year when Richmond City came before the Crime Commission to talk about the number of guns stolen from cars. Last year it was 714. I think this year 680 some. Central Virginia, Lynchburg area, 1,369 over a 4-year period in Campbell, Bedford, Lynchburg. Hampton Roads, it's happening pretty much everywhere. And the issue that we are dealing with here is that we're arming, young people who are stealing these guns. The state police have tape of kids walking up and down the street, shaking car doors, trying to get in. And what has become, back in 2010, before 2010, excuse me, basically to have a concealed weapon in a car, you had to have a concealed weapons permit. And but what we changed it to was all you had to do to have a gun in your car was to secure it, put it in a door slot, put it in somewhere where it wasn't rattling around. And unfortunately, people leave them in visible places. One of the current trends seems to be you take a handgun and you shove it down between your seat and the center console, visible for anybody who walking down the street. And you go into the 7-Eleven, you come back, your gun's gone. You leave it in the car, somebody breaks into it and gets it. It's an epidemic. 77,000 guns a year stolen from cars. It used to be stolen from cars. It used to be most of the guns were stolen in burglaries. It was 3/4 burglary, 1/4 cars. Now it's 50-50. This is aisle 6 at Walmart. Where anybody going out to shop for guns, either for criminal activity or for selling those guns, it's just epidemic throughout the United States. A gun is stolen from a car every 15 minutes. And this is a minimalist approach, Mr. Chairman, that I'm hoping the governor can look at favorably. The Department of Juvenile Justice, of which I used to be the acting director, I put in risk instruments years ago to determine who should go into detention so that we were locking up people we were afraid of, not just kids we were mad at. And the department has had to override that because of the epidemic of young people being caught with firearms in violation of the law. And so they're being locked up. It's costing us money, and it doesn't do these kids any particular good, doesn't teach them a lesson. They continue to do it. And so this is a minimal approach leading to a $500 fine and the potential for getting your car towed. And Mr. Chairman, that is the bill. I think it's easily enforceable, and it will start down the road of beginning to turn the tide here on this epidemic that we're facing.
Hey, Senator, I had one quick question. Why did you limit it to handguns? Why didn't you say any gun?
Well, I am not anti-hunting, and those who have a shotgun rack on their back of their car, I did not want them to be penalized in that regard. I don't think there are many people who hunt with handguns. And I'm trying to be reasonable here, and I'm trying to get a start at some gun control that my Republican colleagues can support, that our governor can sign, because this is a huge, huge underreported problem. Just pull up on your cell phone right now, guns stolen from Virginia in 2023. The articles just start popping up and populating your cell phone. This is serious business, and this is a light approach, but it will send a message, I think, to the to the folks out there that they need to be careful with these guns. We didn't have these kind of problems when you had to have a concealed weapons permit, and now you don't, and now we do have those problems.
Okay, Senator Peake.
Several questions, Mr. Chairman, for the patron.
Okay.
First, Senator Marsden, you mentioned they can be towed. Is there any limit to the amount the towing company can charge for towing these vehicles?
Only within the state law that we provide towers with their ability to charge for towing services. So that's up to the General Assembly. And but the idea there is hopefully you will go and pick up your car quickly, and you know, in the case of a first offense, I hope judges are reasonable in terms of, you know, the fine that they put out there. But basically, we're talking about a traffic offense here.
Mr. Chairman.
Senator Peake.
Do you have any corresponding legislation to increase the penalties for the people who are stealing the handguns out of these vehicles?
Yeah. Well, for those of you on the courts committee know it better than I believe it's quite seriously against the law to break into somebody's car and steal anything. I don't know that increasing the penalty would accomplish anything. I'm fine with with enforcing the laws we have and increasing them if we need to. But this isn't designed to punish, gun owners overly severely. You see, Senator Peake, that I have, purposely kept this from being a misdemeanor or something that goes on your record. I'm just trying to get the word out that this is a horrible, horrible practice that people have gotten into, and we need to stop it.
Senator Peake, you done with your multiple questions? Okay, Senator Stewart.
Thank you, Mr. Chairman. I appreciate what Senator Morrison's trying to do here, and I get at what he's trying to get at. We've actually talked about this, and I think prior debates on bills, we've talked about the fact that it doesn't make any sense that you can leave your gun up on your dashboard, but if you put it under your seat, you could be convicted of carry and conceal without a permit, which is a Class 1 misdemeanor and 12 months, $2,500 fine. But that's my concern. How do you jive this with potential conviction of carry and conceal without a permit, which people do? So if they put it under the seat or somewhere where it is not visible, but it is on their person, as that is a term of art under the law. In other words, they can get a hold of it to use it. When they get back in the car, could they then be convicted of carry and conceal without a permit?
Mr. Chairman, Senator Stewart, my understanding is that used to be the law. But the law now is you do not have to have a concealed weapons permit, and you just have to secure the gun in your car. A door slot works. Shoving it down between the seat works. It just has to be secured. We changed that law in 2010. It came over from the House. It came over the House as locked in your car. Governor McDonnell amended it to secured in the car, which basically means, secured in one spot, which a door slot accomplishes that. Shoving it down the seat accomplishes that. You put it under your seat and it's out of sight. You're not violating this law, nor under current Virginia law, as far as I know. Are you violating the concealed weapons if you're driving that vehicle?
I
Senator
thought
Stewart,
you were.
you answered there.
I thought you were, but perhaps I was wrong about that.
Okay. Senator Jordan keeps using her button properly, and I keep ignoring my screen. Senator Jordan.
Thank you, Mr. Chair. Question for the patron. So I'm looking at this, and so say that a law enforcement officer is off duty but takes his vehicle to the courthouse and parks in order to go and go through the docket of tickets he's written, and he goes to General District Court. If his gun is visible in, say, a belt or in the side pocket of his front seat, this would still apply to him because I see no provision. Is that correct?
I'm sorry, I missed the first part of who are you talking about here?
If a law enforcement officer is going to General District Court off duty or on duty, doesn't matter, and he has his vehicle parked in a public parking space at a court building and goes into the building, leaves that gun secured but visible, would this apply?
I would not imagine that it would. I can't imagine an officer leaving an open handgun in a car, other than I think sometimes they have shotguns or whatever, and it wouldn't apply to that. But
follow-up question, Mr. Chair. I think I don't see a provision in the bill, Senator Marsden, but I think that it might be something we may want to ask, because I do believe that law enforcement officers, when they do go to court, especially, do secure their guns legally but visibly in their vehicles.
Mr. Chairman, Senator Jordan, I'd be fine with an exclusion for law enforcement, in this bill. They are not the problem. But even they can inadvertently do that. We've had a number of situations here in the Commonwealth where police cars have been stolen, and but if in concept we would like to do that, or I can amend that on the floor, I have no problem with excluding police officers.
Okay. No further questions for Senator Marsden. Okay. I'm going to go to support and opposition. I'm going to go 5 and 5. Probably won't need it, but go ahead.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. However, limiting it just to public places, we would like to see this also cover your driveway because we do have a serious problem of guns being stolen from vehicles. And those guns are not like stereos. If your stereo is stolen, you know that nobody's going to take it and kill someone else with it. But a gun, it's a different thing. Those guns are not going back into the regular market. Those guns are going into the underground market. And we've heard many times people say, well, you'll never stop criminals from getting guns because they can just get one from the black market. Well, where does the black market get them from? And the answer to that is a large number of the guns that they get into the underground market are from stolen guns that were in people's cars. Thank you.
If there's anyone online that would like to speak for this bill, please raise your hand.
Mr. Chair, members of the committee, Matt Mansell, on behalf of Everytown for Gun Safety, we support this legislation.
There is one person. Virginia, you may unmute. Make sure your camera is on.
Virginia Rovnak, Charlottesville's Coalition for Gun Violence Prevention and the Charlottesville Center for Peace and Justice. This is an obvious gun safety bill, and I strongly support it.
Good morning. As a volunteer with Moms Demand Action for Virginia, I strongly support this bill, but we do ask that we move forward with a stronger bill to secure storage in vehicles and homes. Thank you so much.
Sorry, that's it for support. When we move to opposition, reset the timer.
If anyone online would like to speak in opposition, please raise your hand.
Philip Van Cleve, VCDL. Number one, on the concealed carry in a car, it's got to be in a closed compartment or container to be legal if you don't have a concealed handgun permit. You can't stick it under the seat. It's got to be in a closed compartment or container. Number two, Richmond is complaining about stolen guns. Well, they're the ones that passed ordinances all over the place. You can't bring a gun here, can't bring a gun there, can't carry them in the parks, can't carry them if there's an event going on, can't carry them in government buildings. And then they're shocked when people have to leave their guns in their car that they get stolen. So I'm not interested in hearing from Richmond about this. Also, now you got a tow truck that's towed off a car with a gun in it. I mean, that sounds good. Let's let the tow company now have access to that firearm in that vehicle. Finally, this blames the victim. You know, your car's you've had a breaking and entering, you've lost your gun, they've broken into your car, and you're going to be punished. It's like everything else right now, it's all upside down. We oppose this strongly.
Mr. Chairman, Taylor McKee, National Rifle Association. We oppose this bill. While we are in favor of safe storage, it should be optional and not mandated. For those reasons, we oppose this bill. Thank you.
Thanks.
Mr. Chairman, Patricia Webb, Virginia Citizens Defense League. I would like to offer some solutions. I do not think this bill is a solution. I think this bill is victimizing a victim again. And I think it is actually a mean-spirited bill. The sponsor kind of indicated his intent when he said he was not anti-hunting. That implies that he's actually anti-handgun. I would submit to you that the solution to this problem is to pass constitutional carry and to get rid of gun-free zones and to better educate the public. This body passed legislation several years ago that allowed concealing a firearm in a vehicle in a secured container without a permit. I still, to this day, have customers coming into my gun store that are absolutely shocked when they find that out. They think that if they put a gun in a vehicle and they don't have a concealed handgun permit, that that gun must be visible or they are breaking the law. So, better education. This body could actually put out there several
notices in newspapers and on television and on social media that this is the law, and to educate people that leaving a firearm in a vehicle is unsafe and puts the guns in the hands of criminals. Guns are frequently stolen out of cars. I would like to see something done about that. I don't like seeing guns in the hands of criminals any more than you do. As far as these youngsters getting the guns and going around checking cars to find what they can steal, how about if an underage person steals a gun, prosecute them as an adult, hold them accountable? Thank you.
Thank you, Mr. Chair. My name is Al Evans with VCDL. I, of course, would like to echo the confusion about concealed versus open carry. I know several people who, we try to do our best, but, you know, when the law is always changing. But specifically with this bill specifically, you know, with the issues in Richmond with people getting their guns stolen, my understanding was mostly it was an unlocked car issue. If you're breaking into somebody's car, breaking their window to go into their car to steal something out of there, you're probably, one, not just leaving with the gun, but, you know, that's, we cannot soften like basically stealing out of people's cars. That's ridiculous. We should not blame the victim for that. Thank you for your time.
Good morning, Mr. Chairman. Dennis O'Connor, Prince George. I'd like to reiterate again that the reason everyone is forced to leave their gun in their car in the first place is because somewhere in their travels during the day, they have to go somewhere that's one of these deadly gun-free zones that invite murder and mayhem, and they have to leave their firearm behind and be have their ability to protect and safeguard themselves and their families' lives have it taken away from them. So I would submit that the solution to this is to get rid of these deadly gun-free zones, which is why schools are always being attacked and children are being killed in the first place, so that people can protect their families everywhere they go. Thank you.
Hello, I'm Regina Payton from the city of Richmond. Gun-free zones are the problem. That needs to be fixed. In my opinion, everybody should be carrying. I don't support this bill.
Mr. Chair, there is no one online to oppose.
Senator Marsden, you have the final word.
Mr. Chairman, just in closing, Henrico County Police report that 10% of car break-ins lead to a stolen firearm in the county of Henrico. That's the kind of problem, that's the kind of numbers we're up against here. And it is giving records to our kids who, this is almost reckless endangerment to leave these visible handguns in cars. And with that, I hope you report favorably on the bill.
Mr. Chairman.
Senator Peake.
Yes, thank you. Speak on the bill. And I was going to ask a question for Mr. Benjamin, who just stepped away. Perhaps council has. Is there any other law in the Commonwealth where we are imposing a civil penalty on someone who is the victim of a crime?
Shopping carts.
No, that didn't pass. That didn't pass. Did it pass? No.
Locality hasn't adopted it yet.
Yeah.
Mr. Chairman,
yeah.
Mr. Chairman, if I might, the crime the penalty here doesn't necessarily have to apply when the gun is stolen. It's just that it's visible. So there is no situation where they're being re-victimized. They are the ones committing the basically the traffic offense of keeping the gun there.
Having a visible gun. Mr. Chair.
Senator Peake.
Well, to speak, I would fully support a bill that created a mandatory minimum of 6 months or a year in jail if you're found guilty of stealing a firearm out of a vehicle. But I just don't think creating a civil penalty for using your constitutional right makes any sense whatsoever in the Commonwealth. I don't know how we can make a civil penalty out of exercising your constitutional right. We need to punish criminals who are breaking into cars and stealing weapons or whatever they're stealing out of the cars. Punish them. Send the message. Make it very clear and very loud that if you break into a car and you steal something, especially a firearm. You are committing a crime, and if you commit a crime in the Commonwealth, we are going to punish you. That's the message we should be sending.
Senator Peake, anybody else have any comments? Okay. This bill does not need to go to finance.
Move to report.
It's been moved and seconded that we report the bill to the floor. Any further discussion? The clerk will open the roll.
Ayes 9, no 6.
Bill reports, Senator Marsden.
Thank you, Mr. Chair, members of the committee.
So we'll debate this Thursday, hopefully not Friday. So I believe this only with committee member bills, and I thought it probably made the most sense to take up Senator Deed's bill first, which was Senate Bill number 2, which is probably the most words of any of the ones we got left to work on. So,
And Mr. Chair, if I can do it from up here, Senate Bill 2 is a bill that you saw last year. It's a bill that passed out of this committee and passed out of the Senate. For a long time, we have looked at bills considering assault weapons. This bill is built on the language that was effective from 1994 to 2004 in the Supreme Court. It's prospective only. It's bans the possession of assault-style weapons that are manufactured after July 1 of this year. It creates a Class 1 misdemeanor. It's identical to what passed last year. And I think it's all there. So anybody that's got any questions, I'll be glad to try to deal with them.
does anybody have any questions for Senator Deeds on this bill we saw last year? There's no differences from last year?
No, there are no differences from last year. The only difference, last year, Senator Obenchain asked a question about the Bruin case and noted that the fact that there wasn't a historical test about assault-style weapons, and the difference is that twice since last year, the Supreme Court has allowed state assault weapon bans to stay in place. So there has been appellate action, and that's the only thing that's different from last year.
Mr. Chair.
Yep.
Senator Deeds is correct. It is substantively the same. I'll just point out there are just a few technical changes made to clarify when the prohibition on a person who is convicted of one of the assault firearm crimes, when their prohibition from possessing a firearm begins. And those changes are just in that new section 182308.1:9 on line 146. It just clarified from when the 3-year prohibition begins. But the rest of it is substantively the same, as Senator Deeds said.
Great. Thank you, Ms. May. Any other questions for the patron? No other questions. Okay, so we'll move to support and opposition. We set it for
If anyone online would like to speak in
5 and
favor of this
5.
bill, please raise your hand.
Yeah, we'll set it at 5 and 5. We have still have a lot of bills left in the docket, and we've heard this one before.
If you're in the room, could you please move closer to the microphone? Thank you.
Good morning, Mr. Chairman, members of the committee. In an effort to be brief, I'd just say we support the bill. Thank you.
Just not right.
Dr. Emily Ann, Virginia Education Association, VEA supports this bill.
Good morning, Mr. Chairman. Tyra Beeman, a constituent of Virginia, and on behalf of Moms Demand Action, the Virginia chapter, we support this bill. Thank you all.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. These firearms were manufactured, advertised, and sold for a type of reason that it should not be available to a civilian, especially an untrained civilian. These are not weapons that are necessary for personal defense.
Tyee Mallory with Virginia NAACP, and like last year, we support the bill.
Good morning, Mr. Chair. Liddy Ballard from Brady. When an assault weapon is used in a public mass shooting, 14 times as many people are injured and twice as many are killed. Brady strongly supports this bill. Thank you.
Mr. Chairman, members of the committee, Jeff Caruso with the Virginia Catholic Conference. Every human life is sacred, and we've said that on many different bills over different years on different topics. It applies here too. We think this bill could save lives, and if it could save even one life, we think it's well worth doing. We urge your support. Thank you.
Mr. Chair, there are two people online. Janine, you may unmute and speak. Please make sure your camera is on.
Okay,
Mr.
online.
Chairman and members of the committee, my name is Jean Hanwich, and I'm speaking on behalf of the League of Women Voters of Virginia in support of this bill. Since 1990, the League of Women Voters has recognized that the proliferation of semi-automatic and automatic weapons in the United States is a major health and safety threat to the citizens of the United States. Assault weapons are exceptionally deadly firearms, commonplace in mass fatality shootings, and should be banned in Virginia. Thank you. Please vote yes.
Virginia, you may unmute. Please make sure your camera is on.
Virginia Rovnak, the Charlottesville Coalition for Gun Violence Prevention, and the Charlottesville Center for Peace and Justice. These rapid-fire weapons are terrible, terrible against the children and people in theaters, people in shopping centers, schools. It's why didn't the police officers run in Uvalde? Because they're afraid that the shooter will have one of these assault weapons and mow them down. They're very frightening weapons, and we should not have them. I strongly support this bill. Thanks, Senator Deeds.
Okay, it takes it with support. All those opposed, come on up. Reset the time.
If there's anyone online that would like to speak in opposition, please raise your hand.
Thank you, Mr. Chairman. Virginia State Police Association, and I represent about 2,200 active and retired law enforcement officers. Some of the things that we've got a concern about is in this bill and on line 301 through 306 talks about the 10-round magazines. You go on further, and it may just be some clarification that needs to be made in it. Down to line 621 through 623, there's an exemption there for law enforcement and for retired law enforcement. One of the problems that I think we're facing here is it talks about ammunition. It doesn't talk about the magazine. A lot of us who are retired from the agency, the state of Virginia sold us the weapon that is a high-capacity magazine. They also sold some of the Colt assault rifles that were used by the troopers that were out on the highway when they transitioned to the Sig Sauer assault weapons, what's defined as an assault weapon in here. I think it's unintentional that our guys are going to get caught up in this because the state sold us weapons that now are going to be a violation of law. And then a lot of times when you work with the Department of State Police and you work undercover, you purchase a smaller type weapon that the department doesn't purchase for you, but you purchase it so that you're able to carry it. And none of my weapons nor anyone else's is less than 13-round magazines. So I think there are a lot of law enforcement that are going to get caught up in this bill that have retired and some that are currently active that have purchased their own weapon. Thank you.
Philip Van Cleve, VCDL, Mr. Chair. Okay, and I mentioned this before. The Supreme Court is not saying in those two cases that came up to it that it agrees, or it's hinting it agrees. It does not go ahead and rule on a case until the lower courts have worked up there. That's what they're basically saying. Lower courts, finish your job, and when it gets to us, then we'll see if you did the right job. So that's not a real indicator. I say in California, they've struck down these kind of bans, so it's not going to go very far, especially considering when it gets to the Supreme Court with Bruin. AR-15s are the most common rifle right now in America and have been for quite a few years, so it's definitely in common use.
Mr. Chairman, Committee, Taylor McKee, National Rifle Association. We oppose this bill specifically on the grounds of Bruin's text history and tradition test. You've got arbitrary magazine restrictions in there, increase in minimum age from 18 to 20-year-olds, depriving them of their Second Amendment right. But there's no historical analogy in the history of this country where the most popular firearm has been banned. Thank you, sir.
Good morning, Mr. Chairman. Patricia Webb, Virginia Citizens Defense League and owner of Gadsden Guns. As Philip was saying, the Supreme Court referred the cases back down to the lower courts with instructions to consider the Bruin decision. So they did not uphold those cases. They just told the lower courts to look at them again and consider the Bruin decision when they were making another determination. This bill does a number of things. It bans most commonly used firearms, and it bans gun dealers like myself from selling those firearms not only to Virginians, but to people in any state where they are legal. So it would put pretty much all licensed FFLs in Virginia out of business, and the manufacturers, I'm considering FN in Fredericksburg, put them out of business as well. So a number of things disturb me. The carve-out for the government elites. It's okay for our government to have supposed assault weapons. Who are they assaulting? If these are truly assault weapons, should our police be using them in the line of duty? I ask you that, and I urge you to oppose this bill. Thank you.
Hello, I oppose this bill.
Al Owens, VCDL, I oppose the bill.
Mr. Chair, there is one person online to speak. Steve, you may unmute, and please make sure your camera's on.
Okay, time's expired, so if you could just please identify yourself and limit your comments to identifying yourself and who you're representing.
Hi, Steve Permon, Jewish Community Security. If I may ask, please, sir. Jurisdictions across Northern Virginia have recognized that in the staffing crisis affecting their ability to provide off-duty details, the critical importance of private and volunteer security for the Jewish community. There have been over 3,000 anti-Semitic incidents since the October 7th massacre. The 10-round magazine capacity limit, the FBI's own research in 2017 found that that's not sufficient ammunition capacity to stop a determined attacker. The Jewish community is scared, and I urge you to please reconsider the scope of this bill because it will leave the Jewish community without adequate security. Thank you, sir.
Okay, thank you. So the time has expired. Senator Deeds, anything else you want to say on your bill? Any other comments?
No other comment, except that while I realize the merits of the bill, of the law, have not been taken up by the Supreme Court, this Supreme Court's not going to allow laws that they know, they think to be obviously unconstitutional to stick. And twice they've allowed state laws to stand. You know, and I think that is consistent with the principle that Justice Scalia noted in a footnote years ago when he said that even this Second Amendment right to possess firearms does not apply to weapons of war that shouldn't be on the street, have no place on the streets of this country. And so I would ask you to report this bill. I'd make a motion to report and re-refer to Finance.
Okay. Sure, it's been moved and seconded, and Senator Stewart has a question. Senator Stewart.
Just very quickly, perhaps to Mr. Benjamin or staff, is there any additional penalty for using an assault rifle in committing a crime? I don't know the answer, and that's why I'm asking.
Mr. Chairman, Senator Stewart, I don't think so.
Thank you.
Okay, any further discussion before we push this bill to the next committee?
Mr. Chair.
Having said, Senator Subramaniam.
Just really briefly, I just want to say I thought it was very telling that we had a religious organization as well as teachers testify as well in support of this bill. You know, my kids go to a religious preschool, and now they've got these thick bulletproof doors and windows, and I just don't understand why we need these weapons out on the street. That's what it comes down to. And so I thank the senator for this bill, and I think we really need to seriously consider this policy for the Commonwealth. Thank you.
Okay. Any further discussion? Clerk will open the roll.
This is not Ayes 9, no 6.
Okay, the bill reports and re-refers to finance.
Mr. Chair.
Yeah, you got another one, but
I've got one more bill.
That's rolling though.
I want to roll that bill. It's 551. I want to roll that. I would like to make a motion to roll 551 into 273.
There's been a motion to roll Senator Deeb's bills 551 into, what was it?
273.
273. Is there a second? All those in favor, please record your vote on the board.
I voted green on something. Yeah.
Button still works.
Ayes 15, no 0.
Okay, thank you, MJ. All right, so that leaves, let's see, Perry, Suravel, Salim, Subramaniam, and Carol Foy. Who wants to go first? Perry, yours is kind of easy, isn't it? So, by the way, Senate Bill 642, I think, is going by for the day. Is that right? Yes. Okay, so all those in favor of taking Senate Bill 642 by for the day, say aye. Anybody opposed? No. Senate Bill 642 is by for the day, and I think there's a related one to that. Salim, right? Yeah. Oh. Can we do motion to roll them together after they've one's by? Who we rolling to who?
Yeah, mine will be rolled into Senator Perry's, and then I'll be a chief co-patron on hers.
Got it. So is there a motion to roll 319 into Senator Perry's 642? Is there a second? Okay, please record your vote to roll together. Incorporate.
Ayes 15, no 0.
All right. So Senator Stanley has 2 green votes today. Senator Perry, why don't you talk about Senate Bill 210, Auto Sears?
Yes, good morning, Mr. Chairman, members of the committee. Senate Bill 210 deals with the manufacture, importation, sale, possession, transfer, or transportation of auto Sears. This bill deals specifically with auto Sears and is in line with the federal prohibition on auto Sears that has existed for many years now. Auto Sears, also known as switches, chips. These are devices that can convert semi-automatic pistols and rifles into fully automatic weapons in less than 60 seconds, resulting in one pull of the trigger that can release all the ammunition in the magazine. Auto Sears have the ability, are considered under federal law to fit into the definition of machine guns, which have been controlled by the National Firearms Act. In the last 5 years, the ATF has recovered more than 31,000 machine gun conversion devices, and ATF is seeking an uptick in these devices being imported from overseas.
Sorry, Sarah, we're trying to figure out what auto Sears are up here. There's been some Googling trying to figure it out.
Right, it does not have to do with Sears, the store. As I said when all of you were talking, auto Sears are devices that are either known as switches or chips that can convert guns. They're very small, they're difficult to detect. But they do allow you to essentially convert your firearm into an automatic weapon. Federally, the possession or transfer of these devices can result in a 10-year prison sentence. And as I said previously, this law just seeks to mimic the federal law that exists and has been in effect for many years. I will say these devices are now able, like many other things we've seen, firearms included, to be created in 3D printing devices as well. I'm happy to take questions from members of the committee.
Senator Stewart.
Thank you, Mr. Chairman. Senator Perry, can you get a federal permit to possess these? Like other things that are illegal, for lack of a better term? Can't you get a federal permit to have these, like a flash suppressor, and I believe?
Mr. Chairman, Senator Stewart, I think that is actually right. I think that's correct. I think you can get a permit to possess them. I have to go back and look at it. I know they do fit the definition of machine gun under the federal firearm statute. And yeah, I think that's right.
Senator Stewart.
I assume that you're seeking to ban or bar these things from people that would use them in crimes or to do evil with it. Is that accurate?
Well, Mr. Chairman, Senator Stewart, I know this point was made earlier as related to the serializing of firearms. And I think what I would say about that is, speaking as a former prosecutor and member of law enforcement, that the problem with, I think, that argument more generally is at the point that it becomes used in the commission of a crime, right, that's an after-the-fact analysis. What we're seeking to do here is to, prevent crime, quite frankly. And certainly things like machine guns that, again, allow for the emptying of a converting and then the emptying of an automatic weapon in less than 60 seconds. If I could go back to your question about the permit for federal law, I think that relates to machine guns in particular. I don't know about the conversion. I think the conversion is actually the problem, is the inability to track that happening.
Senator Stewart. So I guess your purpose is to ban them together so criminals can't get them.
Mr. Chairman.
Purpose is to ban them all together so criminals can't get them. Is that the point?
Mr. Chairman, Senator Stewart, maybe I can help. Switches are easily available on the internet. And what they do is they permit you to turn a handgun, for example, a semi-automatic handgun, into a machine gun. But that kind of understates the problem, because once you pull the trigger on one of these that have been converted, it just dumps all of the ammunition. And it's almost impossible to control. You have to have tremendous training to control that. And so I think that the purpose of the bill is not just to get at criminals, but to get at any ordinary person without the training possessing such a thing, because of the potential to just spray ammunition in undisciplined manner.
Thank you, Mr. Benjamin. And he's right. Having fired these in the Marine Corps many years ago, that's exactly what it does, and it's a blip. But I'm just trying to understand the purpose of the bill. You want these things to be illegal, period, so criminals can't get them to harm people with. I mean, you wouldn't have any objection to somebody shooting a watermelon in a field when you've got 1,500 acres and you're in a 300-acre field of corn, and they want to do it for fun.
Well, I think, Mr. Chairman, Senator Stewart, I think in as in all things that relate to the criminal law, we have to take a look at, what it is we're seeking to regulate and whether or not it's in the public's interest, right? For safety reasons, not just people who intend to use it for criminal purposes, but as was just pointed out, because of the dangerous nature of them. You indicated you operated one in the Marine Corps. I assume that was under supervision and with instruction. I think the concern here is one, the large availability of these that we've seen, and two, the dangerous nature of things that come along with them, even and the easy applicability to other firearms that would otherwise be not as dangerous or not as deadly, and the rapid acceleration of being able to do that with a small device, with a small clip. And so I think that is really what we're trying to do is trying to look at all of those things. And as I said, the federal government passed this law many, many years ago now because of those same concerns. But what we're seeing now is an uptick in the import and the ability for people to access and to use them. And I think that creates a public safety issue. And so really that's what I'm concerned about.
I have a question for Taylor or Steve. So, Mr. Benjamin, Ms. May, so the way I read lines 20 through 22, wouldn't that mean that if you had federal authorization to possess one of these things, that you would then be okay to possess it under this state law?
Mr. Chair, that's correct. If there are auto sears that are you're permitted to possess or manufacture under the National Firearms Act, then you're accepted from the statute.
Great, thank you. Any other questions for Senator Perry before we get to testimony? Okay, let's go to 5 and 5.
I will just say the same bill. There's a companion bill in the House that passed out of the House unanimously.
Okay, thank you.
If anyone online would like to speak in favor of the bill, please raise your hand.
308.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. Just in the last year, the Virginia Association of Chiefs of Police held their annual meeting, and we heard a presentation from the ATF. It was very, very chilling what these pieces of hardware are doing and the danger they're putting our law enforcement in. They're small. They're about the size of a little Bic lighter, 1 inch by 2 inch, 2 inch by 2 inch. The ATF is sharing that criminals are keeping the switch in one pocket and the handgun in the other pocket, and then they just easily just click them onto the back of the firearm and then use these to create a fully automatic machine gun. They're dangerous, and they put our law enforcement at increased risk of harm. And I think support the senator on the bill and support the regulation. Thank you.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety, we support this bill. Mr. Benjamin definitely made it very clear that once you start to pull that trigger and the gun is firing continuously, it's extremely difficult to keep that gun on target. If you're trying to kill a watermelon, you probably wouldn't want the gun flailing all over the place anyway.
Good morning, Mr. Chair. My name is Anton Bell, and I'm the president of the Virginia Association of Commonwealth Attorneys. I'm also the Commonwealth Attorney for the City of Hampton. The Commonwealth Attorney Association seriously support this bill. These items are extremely hazardous to public safety. As already mentioned, they're very small, they're easily attachable, and once attached, they are always on automatic mode. The problem is, even if you're an expert with handling a firearm, these items have the ability to spray up to 60 bullets within a second or two. And as such, even if you're an expert, the targets that you are trying to hit, you're most likely are going to hit other targets besides it. So as a result of that, it is an extreme risk to bystanders, it's an extreme risk to law enforcement, and it's an extreme risk to our public safety. Thank you.
Good morning, Mr. Chairman. Liddy Ballard from Brady. For the aforementioned reasons, we support this bill.
Tayi Mallory with the Virginia NAACP. We support the bill, and we also support the identical bill that passed in the House committee last week.
Good morning, Mr. Chairman. Tyra Beeman from Moms Demand Action. Thank you, Senator Perry, for introducing this bill, and we strongly support this legislation. Thank you.
Mr. Chair, there are 4 people online that would like to speak. Aaron, please unmute and make sure your camera is on.
Okay, 4 people, and we got 2 minutes, so please be brief.
Good morning, Mr. Chair. My name is Erin Earp. I'm with Giffords. I just wanted to provide some additional information. Because an auto sear is classified as a machine gun under federal law, and all machine guns made after 1986 are banned except for military and law enforcement, there are not civilian licenses to possess auto sears under federal law. And Giffords supports this bill. Thank you.
Janine, you may speak and make sure your camera is on.
Hello, Mr. Chairman and committee members. My name is Jean Hanowich from Chesapeake, Virginia, and the League of Women Voters of Virginia supports this bill for all the previously mentioned comments. Thank you.
Ramin, you may speak and make sure your camera is on.
Good morning, Ramin Fadahi, Commonwealth's Attorney from Norfolk. I second my colleague Anton Bell's statements. I would also say that this is another situation where we should not have to rely on the federal authorities to keep us safe. I have a federal prosecutor on staff as a special assistant. They're taking as many of these cases to the Eastern District as possible. But these are incredibly dangerous weapons that are wounding and killing people, and we need to be able to prosecute the possessors of them in the Virginia court system.
Virginia, you may unmute and please make sure your camera is on.
Virginia Rosnack, Charlottesville Coalition for Gun Violence Prevention, and the Charlottesville Center for Peace and Justice. These horrible weapons should not be permitted. They're not permitted by federal law. Let's not have them permitted in state law. I support the bill. Thank you.
Mr. Chairman, there are no more to speak.
Okay, let's reset the timer and go to opponents of people who want it to be legal to possess things that are legal under federal law.
If there's anyone online that would like to oppose, please raise your hand.
Good morning, Mr. Chairman. Dennis O'Connor. I urge your opposition to this bill. Thank you.
Okay, thank you for being brief. Okay, does anybody else oppose the bill? Anybody online?
There is no one online, Mr. Chairman.
Okay. All right.
Mr. Chairman, we have 3 friendly amendments.
Okay, what are the friendly amendments recommended by council?
On line 14, after the word device, insert the words other than a trigger activator as defined in 18.2-308.5:1. And I'll note that that's a specific definition, and so the 2 need to be separated. On line 15, before the word firearm, insert semi-automatic. On line...
Sorry, council, we have a question up here. You could go back to the prior amendment, the definition that you were trying to pick up.
Okay, Mr. Chairman,
could you just repeat it?
Sure.
Just a little,
sure.
I couldn't hear it.
Sorry. The code section is 18.2-308.5:1. And that defines trigger activators or bump stocks. And Mr. Chairman, the other amendment on line 14 would be to delete the words metal or plastic. And on line 15, insert the word semi-automatic in front of firearm.
Okay. Is there a motion to adopt those 3 amendments?
So moved.
Is there a second? Okay. Any further discussion about the amendments? All those in favor say aye. Aye. Anybody opposed? No. Okay.
Mr. Chairman.
Amendments are adopted. Senator Stewart.
Mr. Chairman, maybe this is to Mr. Benjamin. Does the language on 21 and 22 or 22 take military people out of this? In other words, we still fire an M16, I guess it's an A2 now, and you only, Mr. Goddard is right, if you want to kill something, you keep it in semi-automatic because you really can't, you're not effective if you put it in fully automatic. But there, still you get training on that is my understanding. At least we did, and I would assume they do today. So do we have any exemption for military personnel that would receive training in this?
Mr. Chairman, I think the answer would be that the weapons that Senator Stewart refers to are weapons that have already been designed to fire automatically, whereas
I don't know.
Whereas this bill speaks solely to a device used to convert an otherwise semi-automatic weapon.
Mr. Chairman, that's my question. Are we confident that this exempts military personnel? Because I don't know the answer to that. And I assume that that's what the language that said person is in compliance with the National Firearms Act, but I don't have the federal code in front of me. I think we should be sure of that.
Okay. Is it something we can look at maybe after this thing rolls, fix it by floor amendment if necessary? Senator Perry?
I'm happy to do that, Mr. Chairman.
Okay, great. So we can keep the train moving here. Is that okay, Senator Stewart? Okay. I had one other question. So for the committee, I guess, or for Senator Perry. Senator Perry, would you consider it to be friendly if we also added that anybody who's in possession of one of these, anybody who has a firearm with a trigger activator the gun would be subject to forfeiture, as we do for other illegal guns under 19.2 through 86.28?
Yes, Mr. Chairman, that would be a friendly
Okay, is there a motion to add that concept? Okay, it's been moved and seconded. Do we add that? Any discussion about that? All those in favor say aye.
Aye.
Anybody opposed? Okay. All right. So we now have a bill amended 4 times before us. And does this need to go to finance?
It does, here.
Okay. So is there a motion to report and read before the bill to finance? So moved and seconded to report and read before the bill to finance. Clerk will open the roll. Where's deeds? Keep the roll open for a second there, Michael. What happened to deeds? He must be in the bathroom. What do we got? Yeah, we can record it. We can record it in a second.
Ayes 9, noes 4.
Okay, thank you. The bill reports and refers to finance, and Senator Deeds is going to tell the clerk how to record his vote there. Okay, that's it for you, right?
Yes, Mr. Chairman.
Okay, so next up, I think we have Senator Subramanian. We got time for one more bill. I think everything else is going to be by for the day. The intention is to do everything on Monday. The bills heard today on Monday, along with the remaining bills that are firearm-related bills. I think there was some Capitol Square bills and a couple others. Okay, Senator Subramanian, you got the waiting period bill, right?
Yep.
And which one is that?
SB 273.
So can you speak into the microphone? What is it?
SB 273.
Okay, 273, and Senator Salim, I think you're getting rolled, right?
Doesn't sound good.
Okay. So there's a motion to incorporate Senate Bill 55 into Senate Bill 273. Oh, we already did that? We already did that? Yeah, this is the third one rolling in. Yeah. Is it a motion? Is there a second? Okay. Please record your vote.
Into 273.
You might want to go vote.
All right, Senator Salim, you've been rolled.
Ayes 15, no 0.
Okay, and Mr. Chair, this already includes
Has your bill too, and I think Senator Dees, do you have a witness still?
I have a witness that's online when the appropriate time comes.
Okay, so remember we got caucus in 11 minutes. We got a witness online, 3 presenters, and we got to go 5 and 5 in debate. Senator Subramanian.
Thank you, Mr. Chair. I'll keep it as brief as I can. We're essentially creating a waiting period from when someone consents to a background check as part of that purchase process of a firearm to when they can get the firearm transferred to them. We're choosing 5 days here as the waiting period. for a couple reasons. One, that put us kind of in the national average of other states as well. It's usually anywhere from 3 to 10 days. I know the other bills that were rolled into this one was 2, one was 3. But in Virginia, our default proceed is 5 days, and which meaning that those who don't know, the Virginia State Police have up to 5 days to complete a background check before a firearm is transferred. And so in some ways, this also allows the background check to be completed. Often those background checks don't take too long to get done, but sometimes they do, and they have up to 5 days anyway. And so, the 5-day waiting period kind of puts this in line with their process as well. And, the policy reason behind this is, I think important. One, there's studies that show that, this waiting periods can reduce homicides by around 17%. And then suicide rates as well. If someone wants to, it's almost like a cooling off period. If someone, wants to take their own life and they don't own a firearm, they can go get one, commit that act. This is actually shown to reduce firearm suicide rates by anywhere from 7 to 11%. So I think it's an important measure. I think it's going to save lives, and I hope the committee will consider it. And Senator Salim is here as well to speak about it.
Senator Salim.
Thank you, Mr. Chairman. I'll keep it brief. Again, I agree with my colleague up here who's co-patroning this bill as well. At the expense of, just to keep it brief, it is going to reduce the suicide rate that happens because somebody purchases a firearm, and whether it's at a gun show or at a place or from someone that they know, significantly. And I know members of this committee, along with the General Assembly, have continuously talked about mental health. This is going to play an important role in that mental health aspect. So I urge you all to vote for this and refer it to the floor. Thank you.
Right. Senator Deeds. We have somebody online.
Mr. Chair, the reason I put in a bill, this might not look like a bill I would have put in before, but this bill is about suicide. I had a constituent contact me in probably April during my primary, contact me by email and tell me about witnessing somebody go into a pawn shop north of Charlottesville, come out 15 minutes later and take their own life in their car on the lot. Now they had gone through the background check. They had done everything they were supposed to do, but that without an involuntary commitment, without a red flag on the record, that person was able to legally obtain a firearm and take their lives. You just don't know whether a person is stable or whether they're unstable, and that's what this bill's all about. And I think there will be somebody to testify more directly on this issue online.
Senator Obachani, you have a question for Senator Deeds, or no?
Yeah, I'll wait.
Okay, so we have somebody online to testify for Senator Deeds' constituent, or could we take that during support, I guess?
Melissa Palumbi, I think, is supposed to be on.
Okay, well, why don't we do support and opposition? We're limited on time here. We can take her testimony during support. So let's go 5 and 5. Okay, let's go ahead, Ms.
Mr.
Haas.
Chairman, members of the committee, my name is Lori Haas. We support this bill. This bill is intended to prevent impulsive acts of violence, whether harm to self or harm to others. We know that there's a person out there thinking about suicide, and firearm suicides are deadly about 90% of the time, whereas other means of suicide are not. Other means of suicide, the success rate results in death perhaps 2 to 10 or 15%, depending upon the method used. Again, firearm suicides are deadly 90% of the time. This bill is intended for the cooling off period and to prevent impulsive acts of self-harm and harm to others. We strongly support the bill. Thank you.
Mr. Chair, there are 2 people online that would like to speak.
Mr. Chairman,
Okay.
Andrew Goddard, Virginia Center for Public Safety. This is a bill which will reduce suicides. And just to flesh out those numbers a little bit, in 2022 we lost 737 Virginians to suicide. That's an incredible number. When I first started coming here, it was down in the 400s. Now it's in the 700s. We need to do something proactively to stop suicides.
Tanya Mallory with Virginia NAACP, and we support the bill.
Good afternoon, Liddy Ballard with Brady. As Andy Goddard mentioned, over 700 Virginians die by firearm suicide each year. This bill will have a tangible impact on bringing down that number, and we support the bill.
Good morning, Mr. Chairman, and thank you, Senators, for proposing this bill. As a volunteer with Moms Demand Action, one of the things that we often think about is how are we de-escalating violence in communities. This bill is a form of being able to allow that, both with homicides and suicides, and to be able to give community partners, many of our community partners who are violence interrupters, give them the opportunity to interrupt the violence in many of our communities. Thank you so much.
Thank
Melissa,
you.
you may
online.
speak.
Yep.
My name is Melissa Palumbi, and I live in Charlottesville, Virginia, and I thank Senator Dietz for inviting me to tell my personal story. It was my husband who drove himself to a pawn shop in Charlottesville, Virginia on June 12, 2023, waited for a background check, which took about 15 to 20 minutes, took the gun, went into his car in the parking lot, and killed himself in his car. And I truly believe a waiting period to purchase a firearm could have saved my husband's life. Lawrence suffered from depression that accompanied a brain injury that he had 9 years ago, and he moved to Virginia to be closer to his family and to be an uncle to his 6-year-old nephew and 9-year-old niece. He was my world and had a wonderful sense of humor, and our house was filled with laughter and love. But his depression came with his brain injury, and in the last year he had suicidal ideations, which we sought acute help for, and he was in treatment. We all observed Lauren doing better, and on our last day I remember his smile as we went to a UVA baseball game as they crushed their opponent before they went to Omaha. At his memorial, friends kept asking me, isn't there a waiting period in Virginia? And honestly, we all assumed that there was one in place. How could he buy a gun the same day and do this? If he had to wait a few days, could it have helped his medication stabilize or be able to change his mind about ending his life? I've learned that traumatic brain injury can lead to great impulsivity, and a waiting period could make it harder for someone like my husband to act from an acute lack of impulse control. There is not a day that goes by I do not wonder if a waiting period could have given my husband a chance to live. And I believe enacting a waiting period to purchase a firearm in Virginia could save someone else's life. So I strongly support this bill.
Thank you, Ms. Palumbi. And I also had a friend who went to Walmart, bought a gun and a $2,000 bottle of wine, taped his account numbers to his chest, and killed himself. So I'm sorry for your loss. It's unfortunate this happens. The last person we have.
Virginia, you may speak.
It's not only suicides. A number of years ago, a neighbor of mine was killed, shot by her daughter who had bought the gun the day before. We need a cooling off period for these impulse shootings to be prevented. Thank you very much.
Thank you. Okay, let's move to opposition. All those opposed, reset the timer, please.
If there's anyone online that would like to speak to oppose the bill, please raise your hand.
Mr. Chairman, Philip Van Cleve, VCDL, we strongly oppose. Number one, when the current instant check system was passed, there was basically a promise to gun owners that, hey, this is no big deal. We'll do this fast 5-minute check, and you'll be able to leave the same day within a few minutes of getting your gun. This turns that to mush. This makes it a lie now. Now we're where we were told we wouldn't be, a 5-day delay. That means if you go to a gun show, they won't be able to complete the sale there. You're going to have to drive across the state, possibly wherever the dealer is that you bought the gun from, to actually go pick it up 5 days later, at least 5 days. It's again, we go back to Bruin. There's no history or tradition of saying you have to wait X number of days to buy a firearm. So we strongly oppose this. Thank you.
Mr. Chairman, Taylor McKee from the National Rifle Association. We oppose this bill as well.
Patricia Webb, Virginia Citizens Defense League, and Gadsden Guns. As Philip Van Cleve said, an instant check is supposed to be an instant check, and a right delayed is a right denied. There are multiple cases as well where waiting periods have cost lives. I don't have specific names with me. I can furnish them at a later date if anyone is interested. Also, as far as suicide rates go, studies have shown that if you take guns out of the equation, those intent on committing suicide find other methods. It's evidenced by the fact that other countries that do not allow civilian ownership of gun, many of them civilized countries, have higher suicide rates than the United States. I suggest instead that we work on reducing the stigma for receiving mental health treatment and seeking mental health treatment, reduce the waiting times for beds in mental facilities. We have defunded mental institutions over the years, and we've created this problem. We need to address that issue instead of denying good people their basic human rights. Thank you.
Al Evans with the VCDL. If somebody is trying to kill you and you are trying to defend yourself, and it takes 5 days in order for you to actually be able to do that, I think that's a travesty. I strongly oppose this bill.
Thank you, Mr. Chairman. Dennis O'Connor. California has a 10-day waiting period, and they have double the violent crime rate. Also, for someone who feels that their life is in immediate danger, that they need a firearm to protect themselves, that puts them and their family at hazard if they had to wait 5 days when they're in imminent danger. Thank you.
Hello, I oppose this bill.
Mr. Chair, that concludes our online speakers.
Sorry, I can't hear you. There's nobody online? Okay, thanks. Okay, which one of you three or all three of you want to have the final word? Any further discussion?
I'll just say I'm an EMT in Loudoun County, and I responded to suicide calls. And the ones where a gun was involved, there's no saving them. It's over. It's just about calling a coroner. But the ones where maybe they try to hang themselves, maybe an overdose, we've saved people in those situations. Using a gun to try to kill yourself is a much different result in so many cases. And so I think that this cooling off period will help in that regard. It has been shown to help based on the research. Thank you.
Great. Thank you, Senator. If this reports, it has to go to Finance. Are there any motions?
Move to report.
Second. I'm sorry. Senator Obenchain wanted to speak, and I forgot.
Just a couple of quick points. Number one, the impulsive behavior. We tried to address that in a bipartisan way back in 2021. I think that the legislation that created the Virginia voluntary do not sell firearms list, I think that passed, and I think it passed with a pretty strong bipartisan majority. I think that's the way we ought to be headed in terms of trying to protect people from that kind of impulsive behavior. Second of all, some people talked about the immediate need for protection, and that's not just a theoretical concern. We have
doesn't apply to you.
Golly. Senator Marsden. We have people who are being granted protective orders absolutely every day, and the issue of violation of protective orders is a really critical concern. We had a situation where there was a double murder out my way from two children being abducted in violation of a protective order, and then savagely being murdered by an abusive former domestic partner. And, we've got people who really do need immediate access to the means to protect themselves, and the lack of any provision in here granting that kind of relief for victims of domestic violence and abuse, or We have prosecutors across Virginia who, or law enforcement, prosecutors who are faced with threats of violence all the time. And I think that I don't question the intentions of the patrons, but I think this is a broad, sweeping bill that is going to have a lot of adverse consequences on protecting victims in Virginia.
Senator
You want to speak, Senator Boysko?
Just briefly, Mr.
Okay.
Chairman. Thank you, Mr. Chairman. I want to thank the patrons for bringing this bill forward. We know that, people impulsively try to kill themselves. And if we can slow that down, quite often we can get them the help that they need. And then you find that they're going to be okay after that. So this is an important bill. I appreciate the patrons for bringing this forward and renew the motion again to pass it on to finance.
Say what? Right.
So
This
I'll
is the motion. Okay.
Restate the motion, move to report the substitute and re-refer to finance.
Okay. And it's been moved and seconded. I know, Senator Stewart, you had something you want to say.
Thank you, Mr. Chairman. And I appreciate what you all are trying to get at. I just don't think this bill does. I recall I've been prosecuting for about 7 months, excuse me, as a newly elected Commonwealth's attorney, and I was prosecuting a drug dealer who was pretty high level, and he was a pretty bad person. And I'll never forget the day the FBI came into my office and said, "You need to sit down. This guy's trying to hire somebody to kill you, your wife, and your children." And my children were, at the time, 6, 8, and 9, something like that. And oddly enough, for a dumb country prosecutor, I didn't own a handgun. All I owned was shotguns because I hunted. But I can tell you that day I bought a 380 auto that was small enough to fit in my pocket. And if I'd have had to wait 5 days to do that, that would have seemed like an eternity. So while you're trying to get to help people who need the help, and I support that, you're also taking away the right of people to defend themselves and their family in that fashion, and I can't support that. And I hope you all will consider that, because these things really do happen.
Thank you, Senator Stewart. So it's been moved and seconded that we report and re-refer the substitute to finance. Clerk will open the roll.
Ayes 9, no 6.
It's been reported, so the bill reports re-refers to finance. That's done. That's the docket for today. I want to note for the committee, we have 106 bills left and 6 committees. So committee will rise.
The Senate of Virginia, Richmond, Virginia.